Good morning, everyone, and welcome to the Township of Georgian Bay for our Planning Council meeting of Tuesday, May 6th, 2025. And I'd like to call this meeting to order at 9 a.m. And in the spirit of reconciliation, we wish to acknowledge the enduring relationships between Indigenous peoples and the territories that they've traditionally occupied. We recognize and deeply appreciate the historic connection they have to this place, the land, the air, the water, and all that live in, on, and above it. We are grateful for the opportunity to meet here, and we thank all the generations of Indigenous peoples who have taken care of this land and who continue to care for it. And we want to show our respect. Hundreds of years after the first treaties were signed, they remain relevant today. May they guide our decisions and our actions. We commit to learn, to honor sacred places, and to take action towards real truth and reconciliation. Miigwech. Council, any declarations of pecuniary interest or conflict of interest or anything else we need to know? Council? Well, we're going ahead without him regardless. It's 9 o'clock. Well, thank you. Yep. Open forum. I understand we might have some people interested in joining open forum. The guidelines for open forum are 2 minutes. Yes, I have a timer. And we're going to try to restrict it to roughly 10 speakers. And I'm going to also ask and advise if as many people who say they want to speak will be speaking. And I don't know how many may be attending online. But if what you have to say has already been said, my advice is don't repeat it. Go on to something that hasn't been said. So I'll leave that with you. Who wants to be the first open forum participant? Come forward and identify yourself, and we'll go from there. All right. Oh, yeah, we need a volunteer to be first. And you're the one who checked time on me. I saw that.
If you could please.
Oh, yeah. Yeah, please come to one of the chairs. You got to turn the mic on, and so there's a little red light showing. That way everybody at home can hear us.
And state your first and last name and the item you're here to speak to as well, please.
My name is Ken Otto. I'm opposing the zoning bylaw amendment application Z2417, the Reynolds parcel of land. My family and I own the land and cottage directly across opposite the Reynolds on the other side of the channel, 43 meters to be exact. We enjoyed our cottage for over 20 years. This proposal will destroy our experience, materially impact its value, and put my family at risk. The Morgan report says it is not anticipated that future development will cause negative impacts to those in the surrounding area. This is false and an ignorant conclusion. The entire recommendation seems to rely on the Morgan planning report. A review from a planner that is clearly biased to the Reynolds request, has no knowledge of the wishes of the lake community and the Narrows in particular, and did not attempt to do any of the work required to study the facts. Nothing about this proposal is consistent with the 6 Mile Lake community's desires. The report says the proposed lot will contribute to the rounding out of the community by allowing for this large land holding to be effectively developed in harmony with the existing character of the surrounding area. This is 100% false. You have 23 letters of opposition. This development will create one of the most dangerous boating areas on 6 Mile Lake and will result in conflicts and accidents. This proposal is inconsistent with every part of the narrow water body bylaws. The measurements provided are inaccurate. The description of this channel is materially misleading, dangerous, and in my opinion, negligent. The planner's report says the recommendation is in alignment with the following pillars: customer experience and community engagement. Nothing presented in the planner report and Morgan report proves this to be true. This is a false conclusion, and again, in my opinion, negligent. For the safety of my family and the lake community, please reject this recommendation. Thank you.
Thank you very much. Anyone else wish to come forward?
Good morning. The protocol directs that I keep my comments to 2 minutes. Respectfully,
The
last night.
protocol also suggests you identify yourself
Oh,
first, even though
thank
I
you.
think some of us suspect we know who you are.
Thank you.
Sorry.
My apologies. My name is Vince Santoro. I live at 862 Haskets Drive. Again, the protocol directs that I keep my comments to 2 minutes. Respectfully, last night I added a third minute, if you don't mind, based on a recent conversation I had with Ken Smith of DM Wills. I feel will be beneficial to your deliberations later today. Before I begin, I have a simple request as well. In November last year, I took 2 minutes of your time to speak on a similar road sale. When I later watched the recording, I noticed many council members were multitasking, reading documents, typing, and not fully engaged. Today, I respectfully ask for your full attention. Thank you. I provided my written reasoning outlining why application should not be approved late Sunday, as my intention is to highlight only 2 points from my written comments. I request an informal show of hands who has actually been able to, has made the time to read my report. Okay. I'll begin. Mayor Couture and members of council, I urge you not to proceed with the sale of the Lakeview Road Allowance at this time. Under the Ontario Drainage Acts, DM Wills and not the township is now the project lead in developing a drainage solution for the Lakeview subdivision. The township now holds party status, like myself. Thus, your role is now to provide input, not dictate directions such as selling this land before a mutually agreed to drainage plan is developed. Moving forward with the sale undermines the very process council voted to initiate it just last month. Does the township fully understand the Ontario Drainage Act and their responsibilities? The action suggests not. Proceeding with the sale before DM Wills has completed their assessment raises serious concerns about whether due diligence is being followed. Proceeding with the sale is also premature and reckless, opening the township to avoidable financial burdens and infrastructure challenges. I encourage council to pause, to allow due diligence to be completed, and ensure this decision serves the long-term interests of the community. I would like to highlight something not in my report. As an experienced subdivision design engineer who has previously worked using the Drainage Act, I strongly believe certain assumptions made at the February Planning Council meeting will be proved incorrect. For example, Ken Smith informed Mr. Mariotti that the Drainage Act allows DM Wills to force the use of private property for drainage works. This was shared with council, and staff appear to be relying on this information to support the land sale. While technically accurate, that advice is not complete. The action also provides for compensation and a time-consuming, and I'll suggest very expensive, appeal process if challenged by a private landowner through a petition or a court proceeding. In addition, the difference between requesting land for a simple ditch
Mr.
versus...
Santoro, you've now taken 4 minutes. You've got 2 sentences and then I'm going to cut you off. This is an open forum. This is not a public meeting. And what You have
Okay.
written us extensively, so most of this information you want to share, we've already received.
Okay. Okay. I also provide okay. In addition, the difference between requesting land for a simple ditch versus requesting land for an attenuation pond can become more complex and costly. And may I add, needless. If you remain patient and delay your decision until Ken Smith provides council with a final drainage design to ensure less complexity and less cost, we'll be ahead.
Thank you very much. Anyone else wish to?
My name is Jenny Lou Santoro. I live at 862 Haskets Drive. Mayor Coster, members of council. Being married to an engineer is an experience. While most couples talk about weekend plans, I get enthusiastic explanations about regulations, culverts, and attenuation ponds. So trust me when I say, I feel the depth of my husband's frustration when legislation is selectively interpreted rather than fully understood. As you may have guessed, currently that frustration is focused on how the township is approaching the Ontario Drainage Act. My career has been in education. Sound knowledge is the foundation of good decision-making. Later this afternoon, in closed session, when council chooses to pause this process, yes, I'm very optimistic, and allows DM Wills the time needed to complete the work that you are paying them good money to do, I have a suggestion. Use that time wisely. There is an old saying, you don't know what you don't know. The University of Guelph offers a highly regarded training course at campuses across Ontario, specifically focused on the Ontario Drainage Act. It's a very popular course, which tells me that this township is not alone in trying to navigate its complexities. The town of Huntsville took a proactive approach and hired an expert from R.J. Burnside Engineering to conduct a tailored training session on site for their staff. So here's my simple message. Now that I've set the stage and the pause button has been hit, and you are waiting for DM Wills to complete their work, use this time to seek formal training to ensure a better understanding of the Drainage Act and its many implications. Investing in knowledge leads to more informed decisions, more efficient solutions, and long-term cost savings. Strengthening council and staff's understanding on the Drainage Act will serve the township and its residents, not just in this situation, but for years to come. I just know in my bones, you will make the right decision. Thank you.
You're sounding a little bit like a teacher.
Well, I said I was.
I know. I couldn't help myself. Thank you very much. All right. Next. Anyone else for open forum? Come on forward.
Hi, it's Scott Rogers. Can you hear me?
I was only here in case Scott could not hear me because the fire. So I'll let him.
Okay. Fair enough. So who do we have on the line that wants to speak?
We have Mr. Scott Rogers.
Let's do him now because he's already speaking up, and then we'll see who else in the audience wants to speak.
Hi, thanks for the time today. I did present this case in February, so I will keep my comments to under 2 minutes. In that time, there was two issues. One, the drainage from Mr. Santoro. The other was an easement issue with the lots beside me. I would like to report, which I'm sure you'll be aware of, I did take township's advice, and I have resolved the easement issues. And Mr. Sampson, who owns Lot 10, has confirmed and has sent in a letter of support. I do want to also make sure that it's stated and recognized that in October 2024, the stewards did apply for the other half of the Lake Road purchase, which Township did approve. And so I am asking just to be treated the same as Mr. Stewart did on that transaction. I would also state too, in regards to the drainage issue, it's my strong view that this this area does not add to the drainage. There is blockage from driveways, and the water would flow to the front of my place and away from the Santoro. So in summary, all the issues that that were discussed in February, I've dealt with. The one objection that remains is Mr. Santoro. Mr. Santoro did object the Stewart's application, but that was approved. So I just asked to be treated the same as the Stewart's. Thank you for your time today.
Thank you very much.
Online, we also have Brenda Pritchard.
Is there anyone else in the audience who wants to have a turn at open forum? All right, let's go to Ms. Pritchard, is it? We'll go to that. And so you have another couple of minutes if anyone changes their mind. Ms. Pritchard, please go ahead.
Okay,
Ms. Pritchard, can you hear us?
I can hear you.
Okay, we can barely hear you.
Okay, I'm trying, apparently my microphone is broken. Can you hear anything?
Well, now it's getting a little louder, yes.
Okay,
Okay, there we go.
okay. My husband and I are abutting neighbors to the applicant at 195 Wild Rice Trail. And we strongly object to this application for the following 4 reasons. At the time we bought our property 15 years ago, we were able to help create road association bylaws registered on title, which specified, among other things, that no further subdividing with less than 200-foot frontage and 2 acres of land or road access was denied. Although the applicant was the president of the road association at that time, he obviously figured those rules should apply to him on his first application. His revised application now almost complies with our road access requirements, but not the current lake or district rules or planning act in terms of frontage, setback, or side yard. We believe that allowing further severance on the remaining lands, the so-called sneaky clause, will in effect create precedent for up to 4 skinny lots in the narrow water body. Mr. Reynolds' narrow measurements cannot be relied upon as accurate at over 70 meters. Google Map measurements show 1 point at 34 meters, while Ken Otto's recent measurements indicate about 41 meters. Any average or mean measurements are irrelevant. Once you have a bottleneck of 41 meters, you have a serious safety concern. Add in 2 or even 4 more docks that extend up to 10 meters, and you have an accident waiting to happen. Once established as a narrow water body, the frontage should be at least 120 meters to hopefully provide some safe point for a dock to be placed, if at all, to avoid collisions with powerboats, paddleboards, canoes, and kayaks, miss important access to other parts of the lake. And God forbid if any of these cottage owners want to go swimming off their docks. Provisions clearly in place to address this issue. We are not content to risk the lives of our families, neighbors, and friends for the sake
We're having we're having a great deal of difficulty hearing you, I'm afraid.
Can you hear me at all?
Barely. I mean, we are clearly emphasizing the importance of the narrow channel. That much we're getting from it.
Yes, and sneaky clause, which allows further severance.
And your 2 minutes are up, by the way.
Oh, well, I'm sorry. I had technical difficulties.
Yeah, no, it's unfortunate about the connection, but I think everybody understands that you're quite concerned about the narrow channel being one of the primary aspects.
That's correct, and it's
Okay, well,
not
thank you very much.
but
All right. A little bit frustrating, but anyone else in the audience wish to speak? Do we have anybody else? Okay,
Patricia Elsie is
Um,
online.
okay. Ms. Elsie? Your microphone is not on, Miss Elsie.
Of course it's not. Now can you hear me?
Now we can hear you.
Oh, sorry about that. My name is Patricia Elsie, and I live at 166 Wild Rice Trail on 6 Mile Lake. I am objecting to zoning bylaw amendment Z24-17, which is the Reynolds lot severance proposal. I am deeply concerned that the planning department would recommend the approval of an application that so blatantly disregards local zoning bylaws and which received 23 letters of objection in December. That is why I am speaking to you today, as written correspondence does not seem to have much effect. The most recent proposal has increased the proposed severed lot sizes, but still does not meet bylaw requirements for lot frontage, front yard minimum, and side yard minimum setbacks. This increase in size is also the bare minimum required to apply for a new membership in the Wild Rice Trail Association and thereby have road access to the new lots. To date, no written application or payment of fees have been received for this matter, and no vote has been taken to accept new members. These lots remain water access only. The SR6-6 lot frontage requirement of 120 meters was mandated by the township in 2009 specifically to prevent the creation of small lots. It was used that year when Diane Waters severed her lot into 3 parcels, each having a frontage of 120 meters or more. The Morgan Planning Report refers to the proposed lot sizes as being generally in conformity with the existing character of the lake. And yes, historically, lots on the lake have been smaller, but that was back in the 50s and 60s when most were seasonal dwellings and cabins. Today, more people are making the lake their permanent home with 4-season multi-generational use. Severances today must follow current bylaw minimums. We can't go back to the building density standards of 70 years ago. That is definitely not part of anyone's vision for the future of our lake and community. Mr. Reynolds, in December at the public meeting, spoke of the narrow water body in front of his property as not being very busy at all. And Morgan Planning would have to agree with him, as their site visits took place in the off-season in November and April, when only a handful of boats are out on the lake. What a different view they would have had if their visits had occurred between the months of May and October. It is not unusual to see a half a dozen vessels all jockeying for position as they navigate that narrow channel. When it comes to safety, it is not just the narrow water body measurement that must be considered, but also the density of traffic. I have no problem with the Reynolds wanting to sever their lot. That is their right. But as Councillor Cooper said so succinctly in December, if you can comply, you should comply. And I only ask that they comply. Thank you.
Thank you very much. Do we have anyone else for open forum? Yes, sir. Yep.
Thank you. I'd just like to put a couple of thoughts out there. I know I only have 2 minutes.
We need you to identify yourself.
My name is Mike Brady.
Mike Brady, thank
I
you.
live at 185 Wild Rice Trail. It is my permanent residence. So I'm just across the road from the Reynolds and down a little bit. I just wanted to bring up a couple of quick points. I know it's been hit before, but precedents. if this is voted on and it comes out successful, you set the precedence for a minimum of 4 out of 12 people strictly on Wild Rice Trail that would be able to do the same, split their lots in half or create little 200-foot lots. And I don't know the number on the rest of the lake, but I think it's pretty substantial. There would be a lot of other people that could follow this precedence and do the same. I wouldn't want to see the floodgates opened and many, many new small lots created on 6 Mile Lake. It's not the look and feel that we're going for. The other thing that hasn't been mentioned now, we've all talked about the narrow waterways and the safety in the summer. Nobody's talked about the winter. I'm an avid snowmobiler. There is a main trail that goes right through that narrows. It's on the Ontario Federation of Snowmobile Clubs. It's a government trail. Any snowmobiler in Ontario can traverse that narrows. It's a very busy narrows in the winter time with snowmobiling. It is a proper staked OFSC trail. Half the snowmobilers are going through that narrows at 70, 80, 90 mile an hour. There are no speed limits on the lake when it comes to snowmobiling. And I'm an avid snowmobiler also. I do enjoy going a little quicker on the lakes. It's nice and flat. I blast through that narrows 100 times every winter. That's the only access from my side of the lake to the other side of the lake. And it's not just people on the lake, it's anybody in Ontario. As I say, that's on the Ontario Federation of Snowmobilers Clubs. It's on their site as a main state trail. There are literally hundreds and hundreds of snowmobiles that go flying through that narrows, quite often in opposite directions at the same time, where you do have to move off the trail over closer to the shoreline as snowmobiles are going in opposite directions. Very dangerous. My last point would only be not if somebody dies there, but when somebody dies, if this is approved, who is responsible? I think the people have spoken from the lake, or a good number of them, that it's a dangerous thing that's been proposed. If it passes, who is responsible for challenges in that narrows? I thank you very much.
Thank you. Anyone else? Anyone else in our audience? Well, then I'm going to declare the open forum segment of our meeting over. And now we're going to go to the Shore Road closing portion of our meeting. All right. This morning, there is a public meeting scheduled for 2 Shore Road closing applications. I will briefly summarize the procedure utilized for the meeting. First, the clerk will advise council as to when, how, and to whom notice of the public meeting was circulated for the proposed road closings being considered. Next, staff will advise of the purpose and effect of the bylaws and provide any other information that is relevant to the applications, and staff will summarize any correspondence on file. From there, the public will have an opportunity to speak and provide comments to the bylaw being considered. Please be respectful of time and be concise with your comments. All commentators are requested to state their name and address. Council will then have an opportunity to provide comments for clarification. I now declare this meeting to be a public meeting pursuant to the Municipal Act of 2001 as amended to deal with the following proposed Shore Road closing bylaws. R2402 for 1455 Harrison Trail and R24-10 for 129 Millard Drive. To our clerk.
Notice of the public meeting was published in a digital newspaper, and notice was sent to the abutting neighbors in close proximity to the property at least 30 days prior to this morning's meeting.
And when I have to say to staff here, I have to say to our clerk again, do I not?
Thank you, Your Worship. I'll just pull up my presentation. Application R24-02 requests the purchase of the Shore Road Allowance at 1455 Harrison Trail. The applicant is requesting the purchase of the SRA to increase the property size. Part 1, shown on the reference plan, shows the 162.92 linear meters at a cost of $242 per linear meter for a total purchase price of $39,426.64 plus HST. The property is zoned shoreline residential type 1. There are no open building permits on file and no correspondence has been received on this application. The subject lands located at 1455 Harrison Trail are situated on the north shore of 12 Mile Bay. Here is an aerial view of the subject lands. The reference plan shown notes Part 1 is a shore road allowance to be transferred and become one parcel of 1455 Harrison Trail. Within the original shore road allowance is a bell easement, gazebo, and boat launch. Staff are recommending approval of this application. Thank you.
Thank you very much. Is the applicant or any members of the public present who wish to make a comment on this application?
I'm not aware of any members
All
of the
right,
public.
not seeing any. I'll turn it over to council. Council, are there any comments or questions? Councilor Predko, please.
Thank you, and through you, Your Worship. Quick question for our clerk, and I'm just wondering if she could please just confirm the measurement that was taken for the shoreline, whether it was a straight line between the 2 points or whether it took into account the peninsula.
It took into account the peninsula.
Okay, thank you.
Councilor Hazelton, please.
Thank you. Could I have the clerk confirm that surveys are required to show the Georgian Bay 177.4 high water mark? Which this doesn't?
So a reference plan is different than a survey. So there is a survey on file. The reference plan that is shown there is what is required for us to register it on title.
Okay.
But it does reference specifically in the survey or the reference plan, it specifically notes that the present water's edge of Georgian Bay as established by the survey is shown hereon and has been accepted as the best available evidence for the limit. Any changes from this position of this limit appears to be as a result of normal and gradual fluctuations within the limit.
So I just find it frustrating because we've been wrestling with this issue on Georgian Bay where 177.4 is the defined watermark, and we really don't care about any other marks. We don't really care where the water is presently. If the survey requires it, why doesn't the reference plan? I know it doesn't impact the sale, but I think if we're going to be accepting documents, they should be reflecting the definitions that we have used in the past.
In this situation, the land registry office's requirement of what is and is not supposed to be on the reference plan supersedes preferences of the municipality.
Okay.
Councilor Cooper, excuse me, Councilor Cooper.
This is going to sound a little bit like stereo, but I am very concerned. I see the water's edge here, not the high water mark. What is worrisome is that the water level over periods of time, anywhere from 5 to 30 years, can swing 7 feet, which would move this line significant distance. In fact, I don't see where the high water mark would be. I just see the water's edge, which the water's edge can be many different locations. And this is a snapshot at what year is it? I don't know. What year is this? Should say on the survey. This is so faint, I am having difficulty.
March of 2024.
It's 2024?
Yes.
Yeah, so it's not at the extreme high, but it's still probably 4+ feet above the, 4 feet, no, be about 2 feet below the high water mark. So I'm just very uncomfortable approving anything like this with this sort of information. Regardless of, the land registry office, and I know that there's a lawyer that we've consulted in the past, one lawyer locally that says that, you know, you can get it at the land registry office registered so everything's perfect. I don't think it is. And I'm not comfortable with this, and I don't think we should approve it. Thank you.
Thank you. Councillor Bochek, please.
Thank you, and through you, Mayor. My question is the planning department. The Shore Road allowance is wanting to be purchased. Is it the entire land adjacent to the body of water? That's my first question, because the arrow points to just the one side. My second question is, in the past, we have always extended the lines out into the water in a straight line in order to display where the property's frontage is. And if, in this case, if we extend the property lines, one line will go into the small bay and the other line would come out into 12 Mile Bay. Can you confirm that that's right and answer my first question? Thank you.
Thank you. Through the mayor, perhaps on the first question, and I'll go on to answer the second question, but on the first question, I'll defer to the clerk in terms of, because I'm not sure what was meant by whether it's the entirety of the lands abutting the water. But on the second item, I think what Councillor Bochek is referring to is how the zoning bylaw treats its requirement for separation of docks and their positioning in relation to adjacent properties. So in that case, the zoning bylaw, and the zoning bylaw only for the purposes of dealing with docks and other shoreline structures, says utilize that sort of straight line projection of the side lot line. But that's a different matter, and it does not prescribe the procedures and processes surrounding the delineation and boundaries of shoreline road allowances. That's not what the zoning bylaw addresses.
Did that satisfy your question, Councillor Bochek?
Yes, my first question was the shore road allowance that is wanting to be purchased. Is it just the shore where the subject lands of 1455 Harrison Trail, where the arrow is pointing to, or is it also the lands that are on the 12 Mile Bay side?
It's both sides.
Both sides. Thank you.
Councillor Jarvis.
Thank you. Through the mayor to the planning department. This purchase would increase the size of the property significantly. As I recall, and I may not recall correctly, that's why I'm asking, if this applicant were to apply to enlarge their cottage, it would still be in proportion to the lands owned prior to the purchase of the shore road allowance, or would it be predicated on the full size of the property, including the shore road allowance?
I can answer that if you wish.
Yes, please.
Is that, generally speaking, the shore road allowance is already taken into consideration for the lot coverage, regardless if they own it or not.
Okay, that's fine.
And through the mayor, further to that, and setbacks, etc., are taken from the high water mark once this. Yep.
Councillor Cooper, you had additional remark?
Yeah, I just wanted to clarify that. So from a planning perspective, the acreage here would only apply to the land outside of, or in the inside of the shore road allowance. Is that what you're saying?
No, the size of the property takes into account the shore road allowance, but the setbacks start at the high water mark for where you are allowed to build.
So the acreage, it's going to, if it's, depending on the year you do this, the acreage could be all over the map. That's another reason that the high water mark should be used for acreage as well. I don't understand why you would have a line that could, so the best year to do it would be in 2013, so that you have a huge amount of extra land. Doesn't make sense.
But at this point, we're not, what's in front of us now is the sale of a shore road allowance, not any building permits or anything that may.
But if it's going to be used to, as a tool.
Except that yeah. We know that the high water mark is what's used to
For
approval
setbacks.
for setbacks.
But acreage.
Acreage would include a shore road allowance, and it would include the shore road allowance whether or not they owned it or we owned it. That doesn't change.
I understand that.
And then the debate that you're asking about, does acreage, is it limited by high water or low market, is a interesting debate, but has nothing to do with this particular application.
Well, except that we're trying to sell something that maybe.
It won't make any difference to that debate.
Why not?
Because that land will count for the acreage and planning approvals, whether or not they own it or we own it.
But the line's going to move. I'm sorry, I'm not getting it. Thank you.
And the other comment I wanted to make with regards to the high water and low water marks and all that is that we made the decision, this council, a number of years ago, that we would be selling shore road allowances based on the linear line as opposed to the square, simply because we know that the width can vary greatly. And my understanding from the interpretation he's got at that point, that means the individual would have rights or own the land from the high water mark down to wherever the water is on that particular year. So yes, their land will expand or shrink depending upon the year. Under the water.
Outside of the shore road.
Yeah.
Oh, sorry,
Okay,
outside
yeah.
of the high water. So.
I'm not, but let's not, right now, we have an applicant who, like many others in the past, is asking to buy the shore road allowance in front of their cottage, and I don't think there's anything unusual about that. All right, any other comments? I have moved by Councillor Graziano, seconded by Councillor Cooper. Be it resolved that Council passed the closing bylaw 2025-039 to stop up, close, and convey part of the original shore road allowance lying in front of Lot 49, Concession 8, being Part 1, Plan 35R 27413, formerly Freeman, now in the Township of Georgian Bay, the District Municipality of Muskoka, for 1455 Harrison Trail for the purchase price of $39,426.64. And the council passed deeming bylaw 2025-040, Lot 93, Plan M413, formerly Township of Freeman, now in the Township of Georgian Bay, the District Municipality of Muskoka, not to be a registered plan of subdivision for the purposes of the Planning Act, RSO 1990, CP 13S53. All those in favor? And that is carried. Thank you. And we have one more, I believe.
Application R24-10 requests the purchase of the shore road allowance at 129 Millard Drive. The applicant is requesting the purchase of the SRA for future development purposes. Part 1, shown on the reference plan, shows 140.55 linear meters at a cost of $242 per linear meter for a total purchase price of $34,013.10 plus HST. The property is zoned shoreline residential type 1. There are no open building permits on file and no correspondence has been received on this application. The subject lands located at 129 Millard Drive are situated on the southwest shore of Gloucester Pool adjacent to Little Lake. Gloucester Pool is part of a regulated body of water connected to the Trent Severn Waterway. Here is an aerial view of the subject lands. The reference plan notes Part 1 is the shore road allowance to be transferred and become one parcel of 129 Millard Drive. Within the original shore road allowance are 2 cottages, 2 bunkies, and 2 docks. Currently, there is an open official plan amendment and zoning bylaw amendment applications from 2023 and a consent application from 2024. These applications are to bring the property into compliance. The sale of the shore road allowance needs to be completed before the 3 open planning applications can be moved forward. Staff are recommending approval of the application to purchase the SRA.
Thank you. Is the applicant or any members of the public wishing to make any comments on this matter?
Not that I'm aware of, Your Worship.
All right, not seeing any. Council, any questions or comments from council? Council Bocek, please.
Thank you, and through you, Mayor, unlike most applications, as the district councilor and the councilor for this area, I received no communications either for or against this application. Thank you.
Thank you. Any other comments or questions? Councilor Cooper.
So this, just on the water level, this is on the Trent Severn, is that correct?
That's correct, yes.
So it's a controlled level that doesn't change.
Correct.
That's reasonable. Thank you.
Any other comments or questions? Moved by Councilor Predko, seconded by Councilor Bocek. Be it resolved that council passed the closing bylaw 2025-041 to stop up, close, and convey part of the original Shore Road allowance lying in front of Lot 20, Concession 4, being Part 1, Plan 35R 227713, formerly Baxter, now in the Township of Georgian Bay, 129 Millard Drive, for the purchase price of $34,013.10 plus HST, and the council passed the deeming bylaw 2025-042, Lot 5, Plan M107, formerly Township of Baxter, now Township of Georgian Bay, the District Municipality of Muskoka, not to be a registered plan of subdivision for the purpose of Planning Act RSO 1990 CP 13 S53. All those in favor? And that is carried. Thank you. Okay, and that ends the Municipal Act public meetings portion of our meeting, and we're now going to go into the Planning Act public meetings portion. This morning, there's a public meeting scheduled for 2 proposed zoning bylaw amendments and 1 official plan amendment. I'll briefly summarize the procedure to be utilized for the meeting. First, the clerk will advise council as to when, how, and to whom public notice of the public meeting was circulated for the proposed amendments being considered. The clerk will also advise of the appeal procedures. Next, staff will advise of the purpose and effect of the bylaws and provide any other information that is relevant to the applications, and the clerk will summarize any correspondence on file. From there, the public will have an opportunity to provide comments on the amendments being considered. Please be respectful of time and be concise with your comments. All commentators are requested to state their name and address and sign in on the sheet provided. After the public discussion, the public meeting will be closed. Council will then have an opportunity to provide comments for clarification. I now declare this meeting to be a public meeting pursuant to Section 34 of the Planning Act to deal with the following proposed amendments. A, the Housekeeping Comprehensive Zoning Bylaw Amendment Z2415. B, the Zoning Bylaw Amendment Z2418 and Official Plan Amendment O24-03 for 15124 Georgian Bay Shore. To our clerk.
Notice of the public meeting was sent by first-class mail to the respective owners and assessed persons within 120 to 800 meters of the property subject to the proposed applications, and to those persons and agencies likely to have an interest in the applications. These notices were sent at least 30 days prior to this morning's meeting. Included in each notice was an explanation of the purpose and effect of the proposed applications, and a key map showing the location of the properties or a description of the lands to be affected by the proposed amendments. Other relevant information may have also been provided. These circulations were all provided in accordance with the provisions of the Planning Act and the Township of Georgian Bay Official Plan. Members of the public are advised at this point that unless they make an oral or written submission to council before council makes a decision on these applications, that any subsequent appeal to the Ontario Land Tribunal may be dismissed by the tribunal. Anyone who wishes to be notified of council's decision respecting the proposed zoning bylaw amendments must submit a written request to the planning department.
Thank you. With regards to the Housekeeping or Comprehensive Zoning Bylaw Amendment 2024-75, have we received any correspondence?
Correspondence relating to housekeeping comprehensive zoning bylaw file Z2415 has been received as follows. One letter was received from the District of Muskoka stating they are not opposed to the application and have provided comments. And one letter was received from Celeste Phillips on behalf of Oak Bay Development opposing the entire housekeeping bylaw.
Thank you. To our planners, Shania Wanfor and Jeff Kratke. You've been on this file for quite some time, I believe. And if you could update us, and we'll go from there.
Thank you, Mr. Mayor, councilors, everyone in attendance here and online, and my learned colleague Shania. My name is Jeff Kratke. I am a registered professional planner and a member of the Canadian Institute of Planners, employed full-time by the Township of Georgian Bay. And this is the public meeting, the first public meeting for the Housekeeping Zoning Bylaw Amendment. Housekeeping is limited in its scope, and we have tried to maintain that limit. Certainly there's a piece of correspondence that council has received which questions that, and we will continue to work with all people involved to hopefully move forward on the basis of modifying a complex bylaw without changing its intent. And from the outset, that has been the purpose of this exercise. We are not trying to change the intent in any way, shape, or form. Some of the public input, though, including input from the district, has noted some important matters that we had previously brought to council's attention before and to the public's attention as being part of future processes, most likely the official plan review and update and the zoning bylaw review and update. However, given comments from the district, staff are now going to be coming back to council at another time with further concurrent official plan and zoning bylaw housekeeping proposals. One regarding source water protection and the other regarding secondary dwelling units. And those are the highlighted matters you see on this table. Shania?
Thank you. So on April 4th, we held an open house in which we presented the proposed housekeeping bylaw, highlighting the proposed revisions to zoning bylaw 2014-75. Since the open house, staff have received comments from and met with planners at the District of Muskoka who thoroughly compared the existing bylaw with the housekeeping bylaw. This resulted in staff correcting the following oversights. So section 4.27 references table 4.5, which no longer exists, as tables 4.4 and 4.5 were condensed into one table. Therefore, this section is corrected to reference table 4.4. Section 431A and B are the same in that they both mention MDS1, whereas B was to say state MDS2. This has been corrected. 435 refers to Ontario Hydro and Hydro 1. Both references were revised to correct the name, being Hydro 1 Inc. The Go Home Bay residential zone requirements in tables 6.3 and 7.3 do not reiterate that buildings and structures are to be set back a minimum of 20 meters from the high water mark, whereas our current bylaw does in a footnote to these tables. Staff created paragraph E, which states additional requirements for buildings and structures in the front yard are located in section 4187 to clearly inform residents where to look for additional setback requirements in the Go Home Bay waterfront community. As highlighted later in the presentation, 2 of the commercial exception zone numbers were mistakenly duplicated in the past, and therefore staff are proposing to correct this by changing the duplicated exception numbers. Table 11.1 has a spelling error, so this has been corrected. Section 14.2 does not include library as a permitted use, unlike the current zoning bylaw. Therefore, the permitted uses section has been revised to include this use. And similarly, section 15.2 omits the secondary dwelling unit use. This use is permitted and this section has been revised. Section 15.3 numbers the table as 15.2, yet 15.1 does not exist. Therefore, the table has been renumbered to 15.1, and all references to this table within the bylaw have been revised to reflect this as well. The word protection was omitted from 17.3. This has been revised. Paragraphs C and B in section 17.3 have been combined for clarification purposes regarding the EP, PSW, and FH1 zones. 2 of the fish habitat type 1 exception zones either had a numbering error or omitted a requirement. Therefore, this has been corrected. And lastly, the holding 6 condition for removal has been revised to reflect the district's preference. These revisions will appear in the housekeeping bylaw that is brought back to council at a subsequent meeting. Oh, and these text revisions were made as a result of comments received from the public and representative of Oak Bay Developments. So section 411H, changes to lot sizes, refers to section 410. It should be, be referring to section 411, which is legal non-complying lots, buildings, and structures. 413, only permitted porches, screen porches to encroach into a front yard, provided they were equal to or greater than 1.2 meters above finished grade. But we corrected this to say porch and screen porches, regardless of their heights, may encroach into the front yard, which is what our current zoning bylaw allows. In the Oak Bay residential multiple zone, yard and lot definitions were omitted. They have now been included in this section and reinforced in the definition section in section 19. And the deck definition has been revised to include composite boards. Okay. Staff found that our definition of gross floor area does not clarify how the floor area of structures without exterior walls, for example, a porch, were to be measured and included in the calculation of gross floor area. We noticed that the defined term covered entrance was also not included in the list of attached structures which contribute to the gross floor area of a dwelling. Without these changes, it could be misinterpreted that only the floor area within the supports of an attached structure are included in the calculation of gross floor area, and covered entrances are not included as they are not specifically listed like porch and sunroom. Therefore, we are proposing to add the text shown in blue to the definitions. Some of the more noticeable changes were required to achieve compliance with the Accessibility for Ontarians with Disabilities Act. In the zoning bylaw consolidation published earlier this year, staff were able to make the font 12 Verdana and create a clickable table of contents. Through this housekeeping, staff ensured that the zoning bylaw contained properly structured headings or sections, properly formatted tables, consistent paragraph spaces and indents, a consistent numbering format, tables with alternative text, and we also removed all uppercase text where it was not an abbreviation, as well as italics. In our current zoning bylaw, the words provision, regulation, and requirement are used interchangeably. To be consistent, staff are replacing reference to provision and regulation to requirement.
Council and those who attended the open house will likely remember that originally we were trying to update all of the township zoning maps, but encountered some technical issues working with the District of Muskoka GIS staff. So that has been left aside for now for a future housekeeping exercise, perhaps. Meanwhile, there's a summary that has been provided with each presentation of the housekeeping amendment. And this summary of the zone changes proposed by the housekeeping amendment are clearly twofold. Number one, Oak Bay, where we're trying to clarify a complex zoning bylaw by reducing site-specific or removing site-specific exceptions to site-specific exceptions and making Oak Bay have a zone, which then has site-specific exceptions, as is shown on that table. Port Severn Park, which is a township-owned property, which for unknown reasons wasn't zoned as a park when it was developed as a park. And then a number of individually owned properties, 4 to be precise, 2 in the Honey Harbor area, and 2 in the McTier area, which for unknown reasons were given the same site-specific exception zone number, even though the meaning of the site-specific exception zones are different and apply to different lands. With the move to mapping amendments only for specific properties, we have moved to a system where the housekeeping zoning bylaw amendment will have a number of scheduled attachments, which are before you now, for each one of those properties. And I want council to note that we are making a commitment on each one of those schedules. And that commitment is that, for clarity, the rezoning only amends the site-specific exception zone number and does not alter the requirements or rights for the use of the lands. And what that is meant to do is to ensure that concerns that have been, I think, validly made by one of the participants in this process are not mistakenly overlooked, and that the township will make good if at a later date we find that we have erred and that we have not brought forward all of the rights and requirements in a specific zone. That being said, we'll just keep scrolling through those. We've also added the legal description to the schedules this time around for all of the Oak Bay lands. The legal descriptions in Oak Bay were quite complex, and given the speed with which these maps were prepared prior to the open house, they did not yet appear on those schedules, but they do now. And then I will turn it back to my colleague. 11. I apologize. It is still me. Section 3, and this actually feeds into the discussion that was just had earlier on today by council with the clerk's department and with the planning department. Section 3 attempts to clarify some very murky waters, pun intended. Our zoning bylaw and our official plan are not especially clear with respect to where land ownership goes below the water's edge. We have attempted, without leaving the housekeeping powers, to clarify it as best we can. However, you will see later in our presentation that we are not completely satisfied with this matter, and there needs to be more done. But this is our best attempt, staying within the very strict confines of clarification of the existing system as to where lot lines, property boundaries, zoning rights exist, do not exist. Excellent. I don't know, my computer has decided not to behave right now. And this next slide as well deals with that, but in other respects. So, for example, we've tried to clarify where the zone boundary is located, given that the existing language was oftentimes confusing. We want to make it very clear, for example, that a boundary indicated following a right-of-way of a provincial highway, etc., shall be where that line is. And so we've reworded it, but the meaning is not changed. And section 4.
Section 4, General Provisions, has been organized in a way that prevents or reduces the need for page hopping and with user friendliness in mind. Requirements that are frequently sought out by our residents were moved to the front of this section. Staff attempted to group sections together in situations where one mentioned the other and or to create a better flow of information. For example, narrow water bodies, formerly subsection 4113.6, and Trent Severn Waterway, formerly section 439, are now both under section 419, being shoreline accessory buildings and structures, water-based. The housekeeping bylaw contains an introduction section, 4.1, accessory building structures and uses, which also refers those who are interested in developing such within Cognizant coastal waterfront community to additional requirements outlined in section 417. In the existing zoning bylaw, there is no introduction, and requirements specific to Cognizant were spread throughout the beginning of section 4.1. By creating the Cognizant Coastal Waterfront Community General Accessory Building and Structure Requirements section, it makes it easier for those within and outside of Cognizant to locate applicable requirements. Note that our other waterfront communities have limited, if any, requirements currently located at the beginning of section 4.1, and therefore staff did not create a new subsection for each. Sections 412 and 413 in our current zoning bylaw speak to front yard setback and yard requirements and clarify such on islands. Meanwhile, section 417 in our current bylaw also speaks to yard requirements. These sections were combined in the housekeeping bylaw, forming section 415. In our current bylaw, it is difficult to locate requirements for residential fences, so staff have clarified the requirements in housekeeping by clearly separating and listing such at the beginning of section 4. Planning staff understand that the vast majority of properties within the township are within our waterfront communities. Therefore, in sections 418, shoreline accessory buildings and structures land-based, and 419, shoreline accessory buildings and structures water-based, of the housekeeping bylaw, we created subsections for each waterfront community, which clearly list additional requirements that are specific to each community. The start of these sections also have similar introductions, which essentially say, in addition to the required setbacks outlined in section 415, an in-water boathouse, etc., may be permitted appertuent to a lot. For additional requirements specific to your waterfront community, refer to subsections 4197, Cognizant, 4198, Go Home Bay, 4199, Palisade Bay, Eastbourne Island, 41910, 6 Mile Lake, and 41911, Wawa-Tacey, as the case may be. The following requirements shall apply. In our existing zoning bylaw, these requirements are mixed together and with those that apply to waterfront properties outside of a waterfront community. Section 411, legal non-complying lots, buildings, and structures, has been substantially revised. The term legally existing has been replaced with legal non-complying. Non-compliance as a result of expropriation or widening has been added for clarification purposes. Paragraph C of this section in our current zoning bylaw has been relocated and rephrased in paragraph E4, which contains requirements for expansions to legal non-complying shoreline dwellings. Also in 411E, staff made it so that someone can look in the section pertaining to their dwelling location rather than in multiple paragraphs to determine permitted expansion. For example, in our current bylaw, section 411E1 identifies the permitted expansions for a dwelling within 10 meters of the front lot line, which includes a 25% increase to gross floor area and a width increase of 20%. However, Section 4 on the following page states notwithstanding these expansions, the gross floor area may increase to 95 square meters and the width may increase by 6 meters. Now, in the housekeeping bylaw, these exceptions or expansions are integrated and not contained within a separate provision. 412, legal nonconforming uses, remain the same except for the relocation of G, existing docks on water access properties, to section 4192, docks, ramps, and boat lifts, understanding that this is the section residents turn to for their dock requirements. In our current zoning bylaw, the docks, ramps, and boat lift section contains 18 requirements listed A through R. Not only did staff relocate dock requirements specific to a waterfront community, but we also organized the requirements into the following categories: number of docks, separation and location, size, and additional requirements. Staff have also removed or limited the number of footnotes in tables throughout the zoning bylaw. For example, footnotes 1 and 2 of the table in the permitted yard encroachment section of our current zoning bylaw are now paragraphs B and C, and the table is in paragraph A. Section 5, being our parking and loading requirements, has been reformatted and numbered so that requirements are easier to locate but easier to reference as well. For example, instead of section 5.2.21.2 identifying the location of ingress spaces, section 5.3b will identify such. Here's another example of the renumbering in section 5. So instead of having 5.2.21.2, it's now 5.3b. Here's an excerpt of the restructuring of our loading space requirements. Across most zones, staff revised the introductory statement in the permitted uses section, and we removed footnotes from the zone requirements table so that they are now paragraphs following the A, B, C format. In section 6, shoreline residential zones, and section 7, shoreline residential island zones, we created subsections for each waterfront community that has specific requirements, whereas in our current zoning bylaw, they are mixed together. Table 8.2, we removed required services, site area within a mobile home park, and setbacks within an individual site within a mobile home park from the zone requirements table, and instead communicated these requirements in subsequent paragraphs, in addition to making the table AODA compliant. This also reduced the number of columns or rows filled with non-applicable. Here you can see how the removal of these sections from the table and the footnotes are presented as paragraphs in housekeeping. Okay.
Thank you, Shania. Section 9 deals with the multi-residential zones, and it includes Oak Bay. Many of the proposed changes are simply, again, a relocation of and clarification of existing phrases and sentences as shown in this slide. The next slide, I think, is much more important for council to take a close look at and to think about, especially given the comments we've received from the planner representing Oak Bay. The proposed table includes a new zone, the Oak Bay Residential Multiple Zone. That zone, the new table doesn't include that zone. It's in its own separate table on the next page. But if we go back and forth between these tables, what you will see is that the RM4 zone provisions that were associated with the Oak Bay site-specific exception zone, which was an RM43 zone, are now combined. So you don't need to look at two locations in the zoning bylaw. The next table includes those. But we have received very valuable comments from the Oak Bay team, and they've helped us improve the housekeeping zoning bylaw amendment, and we will continue to treat their comments very seriously and carefully, and we look forward to further discussing them with them. I think what is also key is when you look later on at the next slide, it shows.
I just want to make a note, the numbering error shown on the slide will be corrected for the next version of the housekeeping bylaw, in case anyone was, caught that. Okay.
And I think that's an error only with the slide, not with the actual text. The Oak Bay site-specific exception zones, which are included on this and the following slides, those parts of this first table at the top, if you go back to the previous slide. Nope, there's a slide in between. There we go. So the table that you see in the site-specific exception zone for the RM43 is now in the OBRM zone, as are those specific policies that follow that table, because that site-specific exception zone RM43 applied to all of Oak Bay, as did the RM4 provisions that it did not vary, but now it would be one single OBRM zone. And then on the subsequent slides, there's a comparison intended to display the site-specific exception zones that were part of Oak Bay that become the various site-specific exception zones that would now be within the OBRM zone. You can go down further. The next one. There we go. Anyways, we will, it is all in your package. So in the zoning bylaw that is attached to the site plan or to the report, it is there. Clearly, Oak Bay has indicated their concern through their most recent correspondence, and we will definitely attempt to address it before we return to council. Shania.
One other thing I'd like to point out is for our exception zone tables, instead of having 6 columns, we've now reduced it to 5, with the last one including all modifications and special zone requirements. So in our tourist commercial zones, requirements regarding the maximum number of campsites, boat slips, and required services have been removed from the table and instead have their own paragraphs below. A similar approach is proposed for Table 12.2, which speaks to our marine commercial zones. Our permitted uses tables in the institutional and rural zones have been reformatted to a list, which also makes for easy referencing. In our environmental protection zone requirements section, we removed the EPPSW, fish habitat type 1, natural state conservation, and natural state island zones from the table, as buildings and structures are not permitted in these zones. Note that column 2 on the proposed table will and has been corrected from EPPSW to EPW, which is wetland, in the housekeeping bylaw, and that'll be provided at the subsequent meeting. As mentioned as part of the district's comments presented earlier, paragraphs B and C will be combined as well. And this is again explaining that all of our site-specific exception tables have been reformatted not only for AODA, but we've merged column 5, which is labeled as special zone requirements in our current zoning bylaw, and column 6, which is labeled as other special zone provisions, into one column, and it's now labeled modifications and additional requirements.
Thank you, Shania. The definition changes fall under sort of 3 categories broadly, and we're just trying to show you examples. We're not going through it line by line. On this slide, 2 definitions happen to be right next to each other in the text, which illustrate 2 of those types of changes. One being day nursery, where it simply was the legislation referenced was incorrect, and we have updated it. And that's true of many definitions. We had definitions that referred to the 1983 Planning Act, which was spent long ago. The other definition amendments have to do with providing clarity. And again, we have not tried to change the meaning, but we've tried to better describe the definitions. So deck, for example, you will see below the existing definition in our zoning bylaw versus the proposed, which as a result of a comment from someone that attended the open house has been further refined to make it clear that we're not prohibiting composite structures to be a part of a deck. And so we do speak to the matter that it's whether it is wood or composite, it can be considered a deck, because that was a question that was specifically asked at the open house. The other group of changes have to do with the clarity provided by reducing the site-specific exception zone levels in Oak Bay. And in the case of yards, and lots, we have required specific definitions in the Oak Bay zone, which exist today in the RM43 zone and have now been moved to paragraphs in the Oak Bay zone. And in section 19, you will notice in the definition of yard in the proposed part at the top of the slide that there is a reference to a paragraph specifically discussing that definition in Oak Bay. So the two are linked. So if someone looks in the definitions in section 19, they will know they need to go to section 9.4 regarding Oak Bay, and vice versa. And lastly, we've heard from council, both regarding housekeeping and regarding other matters, as we did earlier today. And we've heard actually from the public that there is some confusion regarding high watermarks, current watermarks. And we have tried our best in this exercise to clarify it, but I think even with trying to clarify the existing, that there may need to be further discussions, which may or may not fall under a further housekeeping. Our initial thoughts right now are that it needs to form a part of the official plan and zoning bylaw review and update. And certainly one approach may be to either replicate the approach on Georgian Bay on all water bodies where an elevation is developed and set, which is the high water mark, or we may need to look at other approaches on Georgian Bay or a combination of those things. Certainly with today's technology, it is far easier, both on the maps and in the field, to identify an elevation mark. And so I think clarity is something everyone's asking for, and we will continue to look at it. And then I'm going to let Shania speak to the last step.
Also, we are still looking into the matter of docks on Go Home Lake, and we'll have a solution presented at the subsequent meeting for that. So the next step is we will continue to revise the housekeeping bylaw based on comments received, and we will prepare a recommendation report and bylaw for council's consideration on June 3rd. Thank you.
Thank you very much. Quite a comprehensive presentation. And I'm going to, again, express my appreciation for all the work that you put into this, and also all the work that various members of our residents and public have obviously informed the work that you're doing, which I think is terrific. And I see lots of council hands, but they're going to have to wait because this is a public meeting. So my next question is to our public. Anyone, whether they're online or in-house, wish to comment on the housekeeping proposal in front of us?
I do have names registered who are present. If you are online and wish to speak, could you raise your hand?
Is there anybody in the house here who wishes to speak to this matter? All right, so then we're going to look to online input before I turn it over to council. No? Okay. We'll turn it over to councilor. Councilor Bocek, please.
Thank you, and through your mayor, I direct my questions to any of our planning staff. And my first question is, previous to the housekeeping law, will that make everything at this current point be legal non-conforming because of the changes to the bylaws? And second, hold on here. I will refer to the GeoHub map of the Oak Bay waterfront townhomes, which I can't remember what page is on, of 168 pages. I really can't remember which it was on, but it did show the waterfront townhomes, the body of water that comes into those, and then there's a borderline on the left-hand side of the page. And I'm wondering what that borderline was or why it is there, because normally that would depict the property line or the waterfront. I'm not sure what that line there means, I wish we could refer to it on the screen, but we're not going to be able to maybe. It was back about 20 pages or so out of the 268 pages.
Through you, Mr. Mayor, to Councillor Bochek, while Shania finds a slide, I believe, for map A8, I think. No, there is no intended change of meaning with respect to legal non-complying or legal non-conforming. For unknown reasons, the bylaw previously to before this housekeeping amendment inexplicably changed its discussion from, for example, legal non-complying to legal existing. And what we've tried to do is not confuse people with using yet another piece of jargon being invented by our bylaw that doesn't seem to have a lot of meaning elsewhere other than this township. There's no change in meaning. It is intended that someone who may have acquired rights, and their acquired rights would predate the current 2014-75, so it has nothing to do with the housekeeping exercise, but they would simply understand that if they were considering acquired rights with respect to a legal non-complying matter, they would look at section, I believe it's 411, and if they were considering rights with respect to legal non-conforming use, they would be looking at section 412, but it has no change. And then in terms of the map, is this the map that you were
Yeah,
asking?
this is the map I was referring to, and the dark line that is on the left side there, I'm wondering if that is because on the right side of that line, that is all man-made. That's all been blasted out and dredged and is not part of the natural shoreline. So is that line on the left-hand side depicting the shoreline that we're talking about?
No, that is the boundary of the Port Severn urban settlement area. And so that boundary line would typically follow the shoreline, but for reasons of which I'm not 100% certain, in that location, it leaves the shoreline and goes out into Georgian Bay. And so there are likely official plan policies, perhaps related to a special policy area or to an environmental matter, which would cover that part of Georgian Bay, which are within the Port Severn portion in section E of the official plan.
Okay, that's a good explanation. The last thing I have to question is during your deputation or during your statement, you made reference to a settlement with Oak Bay. And you can rewatch the video if you want, but I was wondering what you meant by this will be part of the settlement with Oak Bay.
If I said settlement, that was a poor choice of words. No, I meant to say very clearly that we've received a lot of valuable input from many members of the public, including the team representing Oak Bay, that have helped us to make the housekeeping bylaw amendment a better amendment. And we hope to just continue to work with them to address the letter that they submitted yesterday, I believe, objecting to the housekeeping amendment, in order to still bring the amendment forward, hopefully with their support. That is our goal. That's what I meant to discuss, describe, or state.
Just wanting clarity, and thank you, you did that. Appreciate it.
Thank you. Can we get the, stop the sharing? All right. It's interesting whether we share or not share. The screen order seems to vary, but I'm going to go now with Councillor Cooper. I'm going to follow the order I see at this point. I get confused.
Thank you, Mayor, and my hand has gone up and down a couple of times at the encouragement of our clerk. So make sure that we give the public a chance first, but I thank you very much for the report. I particularly like to thank you both for your comments about addressing the high water mark versus the water level, etc. Or at least those are my terms. And wanted to encourage once again, I know I've said this before, but I'm a bit like a broken record as it pertains to water levels. And because they're so significant in terms of how it impacts our shorelines. And I just want to encourage you to continue down that road, trying to bring clarity to the terms and the actual meanings of the terms. Specifically, I'm going to repeat that on the Great Lakes and coastal Georgian Bay, of course, there is a high water mark, and the reason being is that there's a 7-foot swing over a long period of time, nothing to do with spring flooding per se. It has to do with more climate. And I think that's a distinction from what may happen in some of our inland lakes. Some of them have water levels that fluctuate in the spring. Some are controlled, as I understand it, like 6 Mile Lake has a sort of more controlled level, regardless of the runoff to the most part. So I think those are all sorts of things that we need to understand from a planning and development perspective to make sure that we are looking at things from, I won't call it a worst case scenario, but only from the perspective of the high water mark or the water level does impact could potentially impact acreage. And I don't think we want to confuse that issue. We want to take the most conservative approach when we do calculate anything. So that's one point. The other point is, and I realize that this work is mostly, this cleanup, shall we call it, the work that you've done, is a lot of it has to do with commercial development. We can see by having gone through this. So there is work for the future with respect to regular residential housing or buildings. And I think that with that in mind, the only thing I would encourage is that that when we get to that stage, that we make sure that we have our open houses at times of year when our residents are here, and when 80+% of our residents are seasonal, they wouldn't be going to an April 4th meeting. In this particular case, there may be people that would be attending it, but not necessarily our seasonal residents. So I just encourage us, you, all of us, to keep that in mind, that it's best to have open houses when there are people here. Makes sense. So I would encourage that. And by the way, how many people attended the open house?
My recollection, we had 2 people, I believe, plus the mayor in person. And I believe we had 4 or 5 people online, of which 2 were representatives of Oak Bay.
So a pretty low attendance is all I'm saying. And so my point.
For housekeeping, actually, I was surprised. It's oftentimes a challenge to get people motivated because we're trying not to change anything. That is our goal. So our goal is to make it more clear and more easily understood. There's been a lot of reorganization. There's been a lot of rewording. But again, the end of the day is not to actually change rights or requirements or permissions per se. And that's where, again, I'm not sure this high water mark, high water level, current water mark falls under housekeeping. We're going to continue to consider that. It may need to wait for the official plan and zoning bylaw review and update.
And I would just, if I may, just follow up briefly and say that it's understandable to me the relatively low attendance at this, but I would say to you that I have attended open houses for this township on a few occasions, and they've been exceedingly well attended when they're held in season, and if it pertains to significant changes more than housekeeping and cleaning up some language. I just want to say that we have some pretty engaged communities, and that's why you see community plans and all sorts of aspects to our township that you might not find in Markham. And I'm not saying that against Markham, just that, you know, you don't get as engaged in the city. Thank you.
Thank you. Councillor Predko, please.
I can let Councillor Graziano go next. His hand was up actually before mine in the reordering of the hands.
If Councillor Predko insists, I'll take his
I do see his order being a little bit different than everyone else's, but for some reason our mayor gets a different screen. Just very quickly, if I may. First and foremost, I want to thank staff, specifically planning, for their efforts thus far. I'm starting to contemplate whether or not it'd be prudent for me to return back to university to receive my accreditation, 246 pages, and the next PDF is that much longer as well. It's quite a bit of planning, and I also want to say and welcome and say that I welcome your puns anytime, Jeff. But with that said, my questions are, I'm wondering whether or not there's going to be any conflicts with regards to our provincial regulations for the rezoning of the park and other areas specific to waterfront protection and or the natural environment. So are there any conflicts there that we're seeing based on this housekeeping exercise?
No, so the OS 110 exception, site-specific exception zone was created specifically for the park. For reasons unknown, it was applied only to the lands that include the boat ramp and the parking closest to the boat ramp. Other lands that are also included in the park, which is already built, so there's no actual change in land use taking place. Other parts of the park which were planned through the Port Severn urban design guidelines and village center plan. Other parts of that planning exercise have been well reviewed. They predate actually the current official plan and zoning bylaw. And it is unclear to all of the current staff as to why the zoning was overlooked at that time.
Fair. And so what I'm understanding is that there's no direct impacts to any of the policies that we have and or conflicts with the province, specifically around environment, not only for the park, but also other areas within our municipality as well.
In this case, it was allowed to be through housekeeping because housekeeping allows where all planning documents above it suggest something should be there, that you can include it in housekeeping. In this case, there's no issue with the PPS, there's no issue with the MOP, there is no issue with our official plan. Whereas with accessory residential, secondary residential units, the current official plan policies do not allow us through housekeeping to make those amendments. Similarly, with respect to source water protection. And in those cases, why the District of Muskoka has made it clear they're very interested. In those cases, our official plan no longer conforms with the district's official plan, and it should. So it is because, unfortunately, the township went through some changes with its planning department, which have delayed the official plan review and update and zoning bylaw review and update. And that's why we're proposing to return with separate specific processes for those matters. But for the park, no, we looked at it and there is no issue with either the PPS, the MOP, or the official plan. And in fact, our official plan, as early as 2009, actually required that we be consistent with the master plan for Port Severn, which has it planned as a park.
Excellent. One additional question, if I may, Your Worship. We've heard numerous times now of the involvement by Oak Bay, specifically attending the open house as well as registering a letter in disagreement here today. And I'm curious to know, are you at liberty at disclosing what their primary concerns are with regards to the housekeeping? Have they identified specifically what the issues are that is tabling and or raising these concerns?
My understanding of their letter is that they're concerned that we haven't included a changes tracked version of the proposed housekeeping amendments. And council may remember early before we embarked upon the public part of this process that we discussed that with council at one of the project planning meetings. Changes tracked is a wonderful tool. However, where you are reorganizing the location of sections, where you are reducing columns from 6 to 5, it starts to break down on its usefulness. It does through colored coding if the user appreciates where something has moved to. it does allow you to follow that, but it doesn't draw arrows. It doesn't say the text from column 6 is moved into column 5. And so a decision was made early on that we were going to not do a changes tracked version. But one of the options that certainly we haven't yet discussed with Oak Bay is whether a changes tracked version, strictly speaking, for the Oak Bay zone might satisfy their needs or not. But we will explore many options with them and see if there's a way for us to satisfy them.
And fair. So what I'm understanding is that it seems to me that their issue is mainly administrative. But could there be any potential litigation and/or legal challenges with regards to what we're attempting to do here in this exercise?
We have no intention of having a dispute with Oak Bay over a housekeeping matter. We will discuss this matter with them and find a way to accommodate them. I hope that doesn't mean that we leave the RM43 zone and its site-specific exceptions with 6 columns instead of 5, where they will not satisfy the accessibility for the AODA requirements, etc. But worst case scenario, I have said numerous occasions before council and in public that if we have to leave the RM43 site-specific exception and the site-specific exceptions to that site-specific exception in place without amendment, we will do so. This is meant to be housekeeping. It is not meant to start a dispute.
Thank you, Worship. Thank you.
Thank you. Councillor Predko, your turn now.
Thank you. And through you, Your Worship, I'm just going to bring my comments up to section 4.1.9.2, subsection 3, and the docks issue on Go Home Lake. So not very surprising. Just for the council's benefit, this provision in the original zoning bylaw from 2014 gave an exemption to Go Home Lake's restriction of having 2 docks. And I've talked to planning about this a couple of times. This was brought to my attention by a contractor and an agent that works with planning on Go Home Lake, that this is a change in interpretation of the zoning bylaw. And I thought that the clerk had this piece of correspondence, but I received it on the weekend from Jack Hope, who worked on the amendment in 2014 as a community member of the planning committee. And had to say this about it, and I will send this to the clerk so it can be part of the official record. But he just says the exception for Go Home Lake was in the original 1990s bylaw, and after way too much discussion around definition of a wharf versus a quay versus a pier versus a dock, not to mention the impact of floating docks versus dock cribs, the limit of 2 docks was approved of, and the exception of the Go Home Lake was kind of ignored. So I just want to make sure that I believe that we have examples of 3 docks on Go Home Lake. So I think that exception has been taken advantage of in the past. And as we're going through this housekeeping, I hope to hear updates on how planning staff treats this in the future. And I think, Mr. Hope in his email says, now, however, with additional dwellings allowed on a single property, I think the limit should be reconsidered. So, as we're going forward to the actual planning and zoning review, I think it's obviously something that can be reconsidered, but from a housekeeping perspective, my perspective is it needs to stay with the exception for consistency. But I will again leave that to your analysis going forward. But otherwise, it's an amazingly impressive review of everything without trying to change anything. So it must feel like you're doing 2 steps forward, 2 steps back some days, but I think we'll be in a great shape for the full review that's coming forward. And that's a great leg up. Thank you.
Thank you. Councillor Hazelton. Great report. Today's exercise where you had before after was very helpful. Thank you. And I tried to keep up, but I got sidetracked with a couple of things along the way. And one of the items I got sidetracked was item 3.2 on page 43 of our package. And 3.2 item B seems to say, if
if I understand it correctly, that lands below the high water mark are deemed to be lakeside zone. Am I interpreting that correctly?
That's correct, and our bylaw already does that. What we've tried to refine and make more clear is our bylaw was less than explicit, although the zoning mapping included with the original bylaw in November of 2014 made it clear that there are some pieces of land, especially along the Trent Severn waterway, which predated its damming. It's to its most recent current regulated level, and where entire lots are actually submersed now, but are zoned and do have rights. And so we've tried to better describe, without coloring outside the lines, what those rights may be. But again, we are hemmed in by this notion that what we're trying to do with this exercise is provide clarity, not meaningful change.
Thank you for that. And I would like us to chat further about this topic. And I won't get into the details other than to say today we passed a short allowance purchase with a survey, a site plan or some other document, not a survey, reference plan that shows a line. But in fairness, everything below the 177.4 will be LS zoned. Is that what you have told me?
In that location on 12 Mile Bay, yes. So despite the fact that an individual, after the existence of the zoning bylaw setting the high water mark as the location for the zone boundary between riparian rights and the lake bed, yes, our bylaw would stand. Where our bylaw was less clear was the existing lots of record that predated it that existed below the water line.
Yep. So I think what's important for us on the Bay is for anybody who buys short allowance, that they would then understand, as I think I've understood today, that it doesn't really matter what you purchased. What matters is at the 177.4 number, anything below that is zoned differently than your shoreline residential or your shoreline island residential. And we have not been communicating that to the purchasers, and I think we should, but that's a separate point, not for today. I wanted to move on to another thing that I stumbled across as I tried to keep up with your massive process here. If I could go to page 46, item 4.1.6. And my question is 4.1.6 on page. Well, what I'm doing, sorry, is I didn't have your presentation to go back to, so I went to the draft bylaw that you put into the package. And so I was looking at 4.1.6, and I think that's where it was. Oh, no, sorry, 4.1.5, item 3. And in item 3, it am I getting confused here? Anyways, one of the things it was talking about what the permitted buildings were, and it referenced 4.1.13 as the permitted section 4.1.3 regulates the permitted accessory buildings and structures that may be located in the front yard or whatever, blah, blah, blah. And so I thought, well, that's interesting. Let me jump to 4.1.13. And 4.1.13 talks about washrooms. That's on page 57 of the package. It talks about washrooms in accessory buildings. And I'm wondering if 4.1.13 is the wrong reference point there. And maybe 4.1.13 should be some other. Does that make, am I making sense? And we don't have to make a big deal of it today. I just wanted to bring it to your attention before I forgot. And you've got another window that you're bringing things back here, but it just seemed that in 415 subsection 3, it referenced 4113, but it doesn't look like 4113 is an appropriate place to go to find accessory buildings.
We are going to have to look into that and get back to you. No, it's a good point. And again, we've been very appreciative of the points that both council, the public have made with respect to that. When you're moving sections about, sometimes a linkage gets broken and it doesn't make sense. So that, no, we very much appreciate that comment.
So I guess my last comment is, and you've heard this before, and you've heard it from Oak Bay because they're complaining about the non-red line version, and I've tried to justify the non-red line version by saying what I've heard from you already, which is it's complex when you're realigning everything and you're pointing from one place to another place and so on. It's difficult to have a red line type version like you would in a Word document where you just make changes. Having said that, what you presented today was probably the most helpful non-red line version. And it would be really helpful going forward if the nature of the changes that you're introducing are similarly not conducive to a red line version, if you could provide this kind of before after kind of structure or existing proposed kind of structure so that we could better understand it. Yeah. Anyway, thank you. That's, I want to pause there. Thank you.
Councilor Graziano.
Sorry.
Councilor Vocek.
Thank you, and through you, Mayor. Just one quick question. Actually, a statement and then a question. When it comes to property under the water, in Tate Township, I owned a waterfront commercial property, and I leased the property underneath the water for a period of 99 years. Can you tell me that you know of any commercial properties or any properties within our township that has a lease with the MNRF over a term?
Most marinas have. Some of the contractors that have water access to their yards do. And that's a separate matter, which again, our bylaw, we're trying to clarify that where there is a water lot, that there may be other than the lake zone applying to it in some instances, whereas in other instances, it would still be the lake zone. And again, there's only so much we can do through housekeeping. This is a matter that requires further work. It is not as clear as we would like it to be. And the quick answer is we're going to keep looking at it.
Thank you.
Councilor Cooper.
Just briefly, I think I pointed this out, but there is an area in northern part of our coastal Georgian Bay where there's a huge amount of water lot that was not just leased but acquired, and acquired in the 1870s. And so you can't even go over the water or over the land that is owned, is I guess what I'm really saying. So there are some real anomalies here that we need to know about. I think you do know about it, or at least I believe it. I spoke to Director Whitlam about this, that there's an area up north that is like that. It's thousands of acres. Thank you.
Seeing no more hands, I'm going to say thank you very much. We spent more than an hour at all this, and I'm sure you have spent days, weeks, months working all in, and we appreciate it. But I think it's an extremely important project because it makes the document just that much more usable, that much more user-friendly. And I'm glad we're going forward with this. I have moved by Councillor Hazelton, seconded by Councillor Jarvis. Be it resolved that Council receive the report regarding housekeeping for the Comprehensive Zoning Bylaw 14-75, housekeeping, and that council directs staff to prepare a recommendation report and bylaw for council's consideration as a subsequent meeting. All those in favor? And that is carried. Thank you. And I'm going to declare a bio break because I want one, and I think all of us should be stretching our legs. So right now my computer says 5 to 11. Let's have a 10-minute break and be back at 5 after 11. Computer time, not wall time. Thank you. All right. We're going to continue with our Planning Act public meeting with the second item, and that is the official plan amendment number 024-03 and zoning bylaw amendment application number Z24-18 for 15124 Georgian Bay Shore. I guess I have to ask you if there's any correspondence, don't I? To our clerk.
Correspondence relating to zoning bylaw amendment file and official plan amendment file Z24-18 and 024-03 was received as follows. One letter was received from the District of Muskoka stating they are not opposed to the applications, providing that the township staff are satisfied that the environmental impact study prepared by Azimuth Environmental Consulting dated September 2024 is appropriately updated, and that the site-specific shoreline natural area and proposed shoreline renaturalization sufficiently protects the ecological functions of the natural features. One letter was received from Kelly Nicholson, Chief Building Official, stating all Ontario Building Code requirements, spatial separation concerns will be dealt with during the building permit process. 5 letters of support were received from Alan Will, Helen and George Will, Susan and John Maynard, Tassie and Robert Grotgrim, and Dave Forrester. 1 letter was received from the Seven Sound Environmental Association stating the application is outside of the intake protection zones in the Township of Georgian Bay. No policies in the South Georgian Bay Lake Simcoe Source Protection Plan would apply.
Thank you very much. Mr. Kratky, I believe this is your file. The floor is yours.
Thank you, Mayor. With your permission, I will share my screen. As soon as my computer lets me hit the share button. Mayor, councilors, everyone in attendance here today online and in public. My name, of course, is Jeff Kratky. I am a planner employed by the Township of Georgian Bay. This is a public meeting regarding applications number 02403 and Z2418 for lands known as, municipally known as 15124 Georgian Bay Shore. The agent representing the landowners is Jamie Robinson of MHBC Planning, and he is here today. The location of the subject lands in our township is just to the north and east of Bosley Island in the Honey Harbor coastal community, and in a more local setting, just to the north of the Muskoka Heritage area to the south. The development that's being proposed is actually already in place. This is a compliance matter that was identified by building staff. There is an expansion to a previously existing legal non-complying, non-conforming dwelling, and there is a new sleeping cabin that was built all without building permits, and now the owners are seeking to rectify that problem. The purpose of the official plan amendment application is to create a policy area, and that name is changing, so I'm not going to focus on it, by amending Schedule D to designate it, by adding a section F.5.8.7 regarding the policies, and then adding the specific policies in F.5.8.7.1, where those specific policies permit an existing dwelling setback 12 meters from Georgian Bay, an existing sleeping cabin setback 13.2 meters from Georgian Bay, and a site-specific shoreline natural area of approximately 51% shoreline activity area, shoreline natural area, and a shoreline activity area of approximately 49%. The zoning bylaws purpose is to implement the policies of that official plan by rezoning the shoreline type 1 residential zoned lands to a special site-specific exception SR1 zone by requiring renaturalization of the shoreline to the point of 51% natural area, and by adding those site-specific zone modifications to Table 6.3 in the SR1 exceptions regarding an existing setback of 12 meters from Georgian Bay and 0.45 meters from the approximately west interior side lot line, an existing detached deck of 7.8 meters setback from Georgian Bay, 4.8 meter projection into the front yard, and a 1.12 meter projection into the approximately west interior side yard, an existing sleeping cabin, 13.2 meters setback from Georgian Bay, an existing deck attached to that sleeping cabin, setback 10.9 meters from Georgian Bay, an existing woodshed an existing woodshed in the front yard with a 9.1 meter setback from Georgian Bay, an existing propane tank in the front yard with an 8.4 meter setback from Georgian Bay and a 3.9 meter setback from the sleeping cabin, and an existing tool shed in the rear yard with a 4.4 meter setback from the dwelling. The effect of both amendments to the official plan and to the zoning bylaw is to allow the owners to apply for a building permit to legalize the existing buildings and structures on the lands. A very abbreviated background where the more detailed background is available in my report is that on October 27, 2021, building staff issued an order to comply under the Ontario Building Code. On October 16, 2024, the agent made applications numbered O2403 and Z2418 under the Planning Act. And on November 15th, I deemed those applications complete. The applications were accompanied by a planning justification report, which is attached to my report, but speaks to an earlier version of the proposed official plan amendment and the proposed zoning bylaw amendment, and a scoped environmental impact study by Azimuth. Since the clerk's already gone into the correspondence in more detail, I will focus on the district comments, which have been substantive and are made with revisions, so the district has commented twice. While not opposed to the OPA, the district has asked both the township staff and the agent to further consider the proposed amendments. As background, the subject lands and the surrounding adjacent lands are subject to certain natural constraints. And those natural constraints include deer wintering yards, a Muskoka heritage area, and an area of natural and scientific interest shown in the pinkish gray. Fortunately, the subject lands are not in any hazardous areas, neither the fire hazard nor, as is denoted here by the very tight lines along the water's edge of the various elevations that the district has now provided to us using the LiDAR mapping, demonstrate that there's a high improbability that these lands could be affected by either wave uprush or flooding on Georgian Bay. The Muskoka official plan shows that the subject lands are waterfront area. They are in a deer wintering area, stratum 2. They are in moderate to high areas of archaeologic potential, but again, they have little wildfire hazard. The adjacent lands are very similar, but they do include, as I previously mentioned, environmental features such as a provincially significant wetland, type 1 fish habitats approximately 300 meters to the southeast in both cases, deer wintering area stratum 2, the Bears Head Lake Muskoka Heritage Area approximately 120 meters to the south of the development area on the lands, not the rear property line. The McCray Lake Wilderness Area, life science, regionally significant area of natural and scientific interest, which is approximately 290 meters to the east. And again, areas of moderate to high archaeological potential and areas of little to high although the high is very distant from this location, areas of wildfire hazard. The Georgian Bay official plan and the Georgian Bay zoning bylaw implement the Muskoka official plan by showing this in the waterfront area, by showing the Muskoka Heritage Area and the PSWs, and the fish habitat ones in the zoning schedule you will see. But these lands, of course, are in the SR1 zone. I've included 3 sets of air photos here because there was a matter that was identified by myself and by our peer-reviewed environmental experts, Hutchinson Environmental, and that is that you will see in 2013, just prior to the existence of this zoning bylaw, there was a very significant amount of natural area along the shoreline. There's a small reduction in approximately the center of the photo by 2018, but in 2023 there is a greater reduction. And that reduction is also apparent when you're on the ground and you're looking at the lands in the front yard. And so that is one of the matters that is discussed in the policies and in the zone that is to be proposed, which would require renaturalization of those lands, but only to 51%. So the proposal is 51, not 75. And again, I've spoken to this. The district comments in particular, they're not opposed to the OPA. They are simply looking to name it something different than it was previously discussed. And so that is still being discussed with the agent. Their discussion with regards to the zoning bylaw amendment is focused on the natural heritage issues. And again, there are still discussions to be had with the agent regarding these matters. But essentially the zoning bylaw amendment that was attached to my report included a Schedule B. That Schedule B would be replaced instead with site plan control and with further environmental discussions. So therefore, I'm recommending to council at this time that you accept all the information at this public meeting, that you refer that information to me, and that I shall not schedule a meeting before you for a decision until such time as all of that information is addressed. Thank you.
Thank you very much. Oh, excuse me. Thank you very much for that presentation, Mr. Kratky. Is the owner and or agent present, and do they wish to make a statement? And yes, I did see you in the background, Mr. Robinson.
Give a presentation on compliances on their property and provide them with some planning support. I did attend the site with them and had a look at what's existing, and I think what's important, there's 2 applications, OPA and ZBA. The reason for those applications, I'd also just like to confirm if there was any tree removal completed on the property, that was also done prior to the Darmagas purchasing the property. What sort of the facts are is that we had a meeting with the neighboring property owners and folks from the area, and the way I could support the proposal was recognizing what's there. Having compliance with the bylaw would actually result in more site alteration. There would need to be blasting on the site. There'd also need to be further tree removal. And this proposal also allows for the revegetation of the front yard. So through a site plan agreement, the revegetation of that front yard of the property. So effectively what we're looking for here is recognition of what's currently on the site, and as a trade-off, what the public interest is that there's now would be a site plan agreement on the site with a revegetation area identified in front of the property. So what the public gets is the protection of the vegetation, the enhancement of the vegetation, and in turn what the applicant gets is recognizing the existing structures that are there. It's kind of a pretty, I think, simple explanation and trade-off of what's there. And we believe there's a public interest in doing that. I've reviewed the district comments. I think all their comments can easily be addressed through the site plan agreement. I think your environmental consultant would be of the same mindset. We're proposing again that revegetation of the front yard to occur. The specific reason for the OPA is the result of the sleeping cabin that's proposed within 20 meters of the shoreline. As you recall, your zoning bylaw and official plan both require the sleeping cabin to be 20 meters set back from the shoreline, and that's not the case. Having visited the site, there is a fairly prominent rock outcropping that exists behind the cabin, and there would have to be some substantial blasting occurred for that for the sleeping cabin to meet the requirements of the bylaw. I think that's all I need to provide today. It's sort of a high-level summary and overview, but again, just the facts are is that there is additional vegetation that gets preserved here, an opportunity for revegetation, and that revegetation and preservation of vegetation through a site plan control agreement doesn't happen if the applications aren't approved. So we believe there's some public interest in doing that. So we'd really like to see this try to that this project and this property to be brought into compliance. So it's carried some heavy weight on the applicant and the owner of the property for quite some time, and he'd like to have that burden relieved. So, and he has taken the step. Again, we did have a meeting 2 weeks ago, I believe it was, the application, and have since received a number of letters of support from the surrounding neighbors.
Comment. I'm going to start with Councillor Bocek, please.
Thank you, and through you, Mr. Mayor, I have a few questions, but before I do that, I'd like to preface that I understand the reason for the rezoning, and I think it's probably the right thing to do to bring this property into order. My question is, you referred to a sleeping cabin. I refer to it as a bunkie. And does the sleeping cabin or bunkie meet the size requirements by the township? I understand it doesn't meet the setbacks, but does it meet the size requirements?
Yes.
Thank you.
Councillor Jarvis, please.
Thank you, and good morning, Jamie. Good to see you. My question revolves around timing of everything. So I'm just curious, and I just need clarification. According to the report, there was an order to comply in October of 2021 with the previous owners. So with that order to comply in hand, those owners went and sold the property. Have I got that right?
Through your worship, no, the order came after our clients purchased the property.
Oh, because so the order to comply. Okay, so how long has the current owner owned the property?
7 years, approximately.
Okay. That provides a little more clarification for me, a better understanding.
2021.
Again, I was going to say, I think the order and the purchase were almost coincident. They're very close to the same date.
So the then owners that were given the order to comply then sold the property. Were you aware of the order to comply is my question when you bought the property?
We were aware of something.
That brings up a string of questions. With an order to comply, I just can't believe there couldn't be some obligations. I guess that's my next question to the owner, and maybe to Jamie. If there's an order to comply when you purchase it, is that why you then proceeded immediately to try and get things put in line? Did you talk to planning after you purchased the property or before you purchased it?
We talked to several people, some people prior
I'm wondering if I could ask you to come forward and actually speak into the mic, because any
Might help,
audience member online is not going to be hearing anything. And for those
Perhaps while he's doing
watching,
that, Your Worship, I can just add that in my report, I do provide additional details regarding the background. And on June 29th, 2022, Flow Drawings and Design Inc., on behalf of the current owner, requested a
Yeah.
pre-application consultation with then JLR acting on behalf of the
That's
town.
exactly what I'm looking at. So my
So
question
there
is,
has been a lengthy series of planning discussion, but of course, there's also been a lot of change at the planning department, which has taken place during those discussions.
and I would have no, I would understand the situation, Mike. I'm just trying to understand the complexity of the purchase with the knowledge of the order to comply and how that affected, I guess, the current owner's purchase and subsequent, I guess, legwork. I mean, you had to make some inquiries, I presume, because of the order to comply. Has that how that transpired?
I did not know of orders to comply. I knew that there were specific things that had to be done to the property to make certain things legal. The complexity of it, we never realized. And it's...
This just comes down to one more question then. So for, not to you, but to our planning department. So I'm just curious how an order to comply gets acknowledged by a new owner. So if a property is up for sale and there's an order to comply on it, is that somehow something that can be looked up or is made, and any possible new owner are they made aware of it?
So my understanding is that orders to comply under the Ontario Building Code are posted on the property. So anyone who would have looked at the property would have seen the posted order to comply. As well, my understanding of the building code, and I'm certainly not a building code expert, so you may wish to ask this directly to our CBO, but my understanding of the building code is that that order is against those lands. And so regardless of whether a past owner is the one who caused the order to comply to be issued, that the order stays with the lands. But if I've misunderstood that, I encourage our CBO to correct it.
If I may.
Thank you, Your Worship. Further to what Mr. Crack, he said he's entirely correct. And through a compliance request from a purchaser's solicitor, for example, that order would be revealed to the purchaser.
So, yes.
Let Mr. Darmaga respond, please.
There, on the property, there was no physical existence of anything in that said we had to comply with anything. There is one now because I nailed it to a tree last fall. But other than that, there was nothing physical there. Nothing.
Thank you. I appreciate that. I just, it's clouding the issue from my perspective, but I understand your situation.
You have to appreciate he's now here trying to
straighten it all out.
Regardless of how much he knew when he made the purchase and whatever relationship he may have had with the prior owner, which may be a little more clouded now, we don't.
Yeah, I guess what I'm trying to do is make sure that for any future situations, it's, I guess, more clear to those involved that this type of thing is ongoing. Anyway, thank you, and I appreciate what you're trying to do.
You're welcome.
Council Cooper.
So my questions are similar to the ones that just have been asked about the previous owner and the circumstances. Were these issues revealed by your lawyers when they reviewed the purchase agreement? Did all of this come up or not?
They were revealed to us by the realtor. That was the primary issue.
So that was written into the contract of the,
I'd have to
real estate contract?
You know, I did not bring it with me today. I can't tell you.
I'm sorry, I didn't hear that.
I'm not sure. I haven't visited that contract since we've signed it.
The reason, okay, thank you. The reason I asked the question is, it strikes me that if that wasn't fully revealed, it should be the previous owners that's fixing this, because there are contracts, real estate contracts, there's legal review, etc. And if that wasn't revealed, the fault should be maybe falling on the previous owner and the lawyers for not finding it and the real estate agent. So I'd like to understand when all this, why this hasn't gone back to the previous owner.
Go ahead.
Through your worship, just kind of a general comment is that there was clearly some missteps on the property in the past. I think we all recognize that and understand that. The legalities around the property being purchased and what happened is all, I think, interesting information. But what's really important for this public meeting today from a planning perspective is the planning merits of the proposal itself, not the history of how we got here. And that'll really be up to Mr. Darmaga if he needs to take action or something about how we came into the property and the expenses to resolve the issue. But what we really need to focus on today, I think, is the planning merits. We're not going to solve those other issues today.
If I could follow up, please. That's lovely, but we're asking for forgiveness here and we haven't got to the bottom of it. So it's forgiveness today against something that happened previously, and I'm not really getting a clear picture that the previous owner is being held accountable at all, and the township's being asked to give forgiveness. So that's really what's going on. Thank you.
Thank you. Any other comments at this point? I guess I have a few comments. While I will admit to curiosity as to how we got here, we are not a court of law, in spite of people occasionally referring to me as Your Honor. I'm not. I'm not a judge. And I recognize, and this is not the first time we've had somebody in front of us who has purchased a property and discovered that the prior owner or owners have done things inappropriately without the proper permissions and whatnot. What we're being asked to do as council is to determine whether or not we believe the application for a zoning bylaw and official plan amendments are appropriate under the circumstances. I think that Mr. Robinson summarized that quite well in the sense that he stated is that if we forgive the locations of the buildings, if I can put it that way, in exchange for further renaturalization of the coastal area of the property, I think that to me that's the balance that we have to consider. I also think it's appropriate to notice that the neighbors are keen for this to happen, and I think for if nothing else, I think because they're going to appreciate the shoreline is going to be naturalized to some extent going forward with this agreement. And so I think, to me, in spite of the fact that we may or may not think that the current owner was treated fairly by the real estate transaction, I think we actually have to just consider from a zoning bylaw and official plan amendments whether or not the what's being put in front of us is a fair and appropriate resolution to the, I'll call it the dilemma that the current owner now faces. Because I think it's also important for us to recognize in this file that if we were to say no, the consequence of that is that the owner would basically have to move those buildings back, whatever the meterage is, like 30 or 40 meters back, or at least, or depending, I mean, the bunkie anyway, and how many more trees will have to come down and whatnot to achieve that, and is that worth us asking the owner to do that? That's my summary of the whole thing. But if there's no other comments at this point, then we're going to have to hand this back to staff to come up with a recommendation for us to consider at a subsequent meeting. So I have moved by Councillor Predko, seconded by Councillor Jarvis. Be it resolved that Council for the Township of Georgian Bay, 1, accepts all information regarding concurrent official plan amendment application number O24-03 and zoning bylaw amendment application number Z24-18 presented at the public meeting on May 6, 2025. And 2, refers all said information and comments to Township staff for further discussion with the agent, district staff, and anyone who commented. And 3, Township Township staff shall not schedule the next meeting of council to evaluate the application until after all comments are addressed. All those in favor? Oh, Councillor Hazelton. You may. Sorry, missed your hand going up.
So I would offer a comment that if this were to come forward in a clean situation, asking for all of these things to be built in these locations, that the answer would likely be no. I can't imagine how this would ever be approved. And I think what I'm seeing here is what I'll call a massive variance based on what exists. And I think that there should be an opportunity to move closer to the shoreline remediation, to the 75%, 25% disturbed, 75% remediated. Given all of, I mean, I don't see much compromise here. I see massive violations of side yards and setbacks and front yards, etc. I think that what we should be considering is holding a little bit more firm on the shoreline natural state, and that's just my comments. Thank you.
Thank you. Council, do you want me to reread the motion? I'm going to say all those in favor. And that is carried. Thank you very much. And this closes the the Planning Act public meeting portion of the agenda. All comments, questions, and concerns raised at the public meeting have been recorded and will be taken into consideration by staff prior to recommendation being brought forward. Thank you. All right. Thank you very much. Next is the Planning Application Staff Report on the zoning bylaw amendment application Z24-17 for 206 Wild Rice Trail. And who do we have online for this one? So this is Ms. Wanfor. I believe this is your application. I'm going to turn it over to you then, please.
Thank you. Through the mayor. The subject property has an area of approximately 36,800 square meters or 9.1 acres and a frontage of 250 meters on 6 Mile Lake, north of Hungry Bay Island. A detached dwelling, accessory building, and dock occupy the lands, which contain a mix of natural vegetation and are densely forested. Granite rock dominates the shoreline. The lands are designated waterfront in both the district and township official plans and are located within the 6 Mile Lake inland waterfront community. The property is zoned 6 Mile Lake residential, exception 6, and abuts a narrow water body containing type 2 fish habitat. The lands are located within a stratum 2 deer wintering area, as well as identified as having moderate to high archaeological potential and have a low to extreme wildfire hazard rating, with the majority of the lands having a low to moderate rating. The applicant brought to council on December 10th the proposal shown here, which included a lot area reduction from 8,000 square meters to 4,700 square meters, a minimum lot frontage of 60 meters, whereas 120 meters is required, a front yard of 20 meters, whereas the 6 Mile Lake residential exception 6 zone requires 30 meters, and a side yard of 5 meters, whereas 10 meters and 70 meters are required. Staff investigated the origin of the 6 Mile Lake Exception 6 zone and the associated side yards. We found that bylaw 1999-116 was incorrectly entered into zoning bylaw 2014-75. It is clear that the northerly and southerly setbacks were intended to apply to docks only. The applicant has revised the proposal to achieve compliance with the minimum required lot area, proposing a minimum area of 8,000 square meters, and they are also proposing to correct the minimum interior side yard error. The proposed zone will also permit a maximum of 1 dock per property that must be in compliance with the township's narrow water body requirements, and will prohibit all buildings and structures within 20 meters of the front lot line, including a boathouse and freestanding deck. The lands to be retained will keep the 6 Mile Lake Residential Exception 6 zone, which will be amended to delete the requirement of a 30-meter front yard and above noted side yard setbacks, which will be replaced with a minimum lot area requirement of 20,630 square meters and lot frontage of 135.8 meters. Note that this will prevent the potential for another land severance unless another zoning bylaw amendment is approved by council to allow otherwise. General policies of the waterfront area include conserving natural landscape features to the extent feasible. New development should generally have a physical character similar to or compatible with existing development in terms of density, lot sizes, maximum building heights, and minimum setbacks. The zoning bylaw amendment will allow for future development on the lands to be retained, to be sited along the boundaries of the dense forest, and development of the lands to be severed will be sited at a 20-meter front yard behind the vegetated rock cliff located along the shoreline, in conformity with the official plan. Around the 30-meter setback from the water, the elevation of the lands drop and the terrain is rather soft or marsh-like, with pockets of granite rock, making for a less suitable dwelling location. Furthermore, development will be subject to the same maximum building heights and minimum setbacks required in the 6 Mile Lake residential zone. As supported by the District of Muskoka's GeoHub, the application will permit a lot frontage and area that is reflective of and compatible with existing lots on 6 Mile Lake. This statement is also supported by the Medland subdivision plan, which indicates 3 of the remaining 7 lots on the west side of Wild Rice Trail have a frontage of 61 to 62 meters. The minimum lot area and frontage for all new lots in the 6 Mile Lake Inland Waterfront Community are 0.8 hectares and 120 meters respectively. Circumstance may occur where smaller requirements are appropriate and desirable, in which variance to these standards may be considered, provided the intent of the official plan is maintained. The proposed lots each have an area of 0.8 hectares, however, a frontage of 61 meters is proposed. As supported by site photos, the lands are dominated by mature trees, for which those within 15 meters of the lake are to remain as part of the natural state shoreline area. Each lot will also be subject to site plan control, and consideration may also be had for the existing lot frontages on the lake, which vary significantly. The principles of the 6 Mile Lake waterfront community state that the visual impact of development from the water is an important parameter in maintaining the character of the lake, and new development will be considered within the context of sound natural heritage planning. Limited new single detached residential uses are permitted in the waterfront community. The zoning bylaw amendment upholds the maximum permitted lot coverage, building height, width, gross floor area, and minimum required setbacks of the 6 Mile Lake residential zone. Understanding the visual impact of development from the water is an important parameter in maintaining the character of the lake. Consideration may also be had for the significant elevation change from the water to the 20-meter front yard, which combined with the vegetation will assist with screening the development from view. Narrow water body is defined as a water body on a lake which has a minimum distance of less than 150 meters from shoreline to shoreline. A lot frontage of up to 20 meters may be imposed, and to determine if the lot frontage should be increased, regard shall be made for the severity of the narrowness of the channel and the impact of the development on water quality, density, navigation, views, and other matters deemed appropriate by the township. A variety of other techniques, such as building setbacks for primary buildings, limitations on the location and size of shoreline structures, retention of vegetation, and appropriate and safe use of lighting will be considered in addition to increased frontage to address issues associated with specific narrow water bodies. As supported by the district's Lake System Health Water Quality Monitoring Program and the district official plan policies, the water quality of 6 Mile Lake is not a concern. With the exception of 1 dock, shoreline structures, which means a structure in the front yard or projecting into the water, will not be permitted on the subject lands. This table highlights the distinctions between the provisions of the 6 Mile Lake residential zone, the current zoning on the lands, and the proposed zoning. As you can see, the lands to be severed will be subject to the same zone requirements as the 6 Mile Lake residential zone and will have a site-specific lot frontage, which as a result limits the maximum permitted dwelling width to 15.25 meters. Additionally, the zoning bylaw regulates docks, boathouses, and boat ports in narrow water bodies. A boathouse or boat port is not permitted appurtenant to a lot located on a water body less than 61 meters in width, which appears to be the case, and a dock is permitted, which may project a maximum of 7 meters from the current watermark. A dock on the lands will also be subject to a maximum length of 10 meters and a maximum width of 3.1 meters. And I just want to, for everyone to recall that the side yards in the table were incorrectly inserted into the zoning bylaw. They were intended to be 5 meters. As a result of walking the subject lands and conducting an analysis of applicable planning legislation, staff agree with the registered professional planner's justification report and addendum. The proposed lot fabrics are compatible with existing and demonstrate the ability to accommodate reasonable building and septic envelopes. It should be noted that the 20 meters is a minimum, and therefore future property owners may propose a smaller footprint and/or increased front yard setback. Not only is the 20-meter front yard also a requirement of the 6 Mile Lake residential zone, it provides for the most retention of natural vegetation and granite rock. Furthermore, there appears to be no natural heritage features that will benefit from the 30-meter front yard, and no planning rationale to uphold the 30 meters. Some of the correspondence received indicate there are members of the public who have the understanding that the proposed lot areas do not comply with the minimum requirement for new lots on 6 Mile Lake, outlined in both the zoning bylaw and official plan. However, the proposed lots do meet the minimum lot area of 8,000 square meters. There appears to be disagreement in terms of the width of the narrow water body. Regardless, the narrow water body requirements outlined in the zoning bylaw apply and permit a dock. These requirements have been reiterated in the proposed site-specific zoning for clarity and transparency purposes. We have also received correspondence which expresses concern for the potential of the lands to be retained being severed once more in the future. However, the zoning of these lands is being amended, which requires a minimum lot frontage of 135 meters and a minimum lot area of 20,600 square meters. Therefore, approval from Council and the Committee of Adjustment would be required to facilitate a future severance. To confirm, planning staff will be implementing site plan control, and the applicant will also need to receive approval from the Committee of Adjustment to create the 2 lots, should the zoning bylaw amendment be approved by Council. Thank you.
Thank you very much. Ms. Lemieux, I see you seated there. As this is not a public meeting, I'm not going to invite you to speak, but if Council, if you have any questions for Ms. Lemieux, she's available to respond to those questions. And with that, I'm going to turn it over to Council, and we're going to start with Councillor Jarvis, please.
Thank you, through the mayor, and thank you for the report and actually clarifying a number of items. I think some of those minimum requirements now being met by the owner's revision are something that we got to take into consideration. I have a question for you. Lots, I'm thinking of the width of the lot at the shoreline and the changes there. How does that compare to, say, lots 6 and 5, those lots adjacent to this property that's being subdivided and the retained property? What's the width of the shoreline on those properties? It looks like they're very similar to what's being proposed in this application.
Through the mayor, if you could please clarify which lots I'm not following.
Lot 6 is, I believe, on the map showing immediately, if you're looking at the map, immediately to the left of the retained lot. There's lot 6 and then lot 5, I believe. I was looking at the numbers that you provided in your report there online on the screen. Actually, it's right there. Yeah, lot 6.
Okay.
which is,
Through the mayor, if you could just give me one moment, I can actually pull up the Medland subdivision
great.
plan
I-
and
just-
get
just-
exactly which lots in the plan.
just out of
have
curiosity,
certain
thank you very
frontages.
much.
In the meantime, we'll go to Councillor Graziano and then get back to Councillor Jarvis. So Councillor Graziano, please.
Thank you, Worship, and thank you to staff for presenting the changes made. I personally have some concerns with regards to the application here, and I'm going to articulate as to what those concerns are. First and foremost, I've received numerous emails concerning this particular application. And based on my understanding, and perhaps the clerk can confirm, there was a total of 23 correspondence on this matter. How many correspondences have been received in favor and how many against?
If I can have 1 minute, I can look that up.
Sure, I appreciate that. I believe that while she's looking that up, from what I reviewed, 9 of the correspondences were of residents on the road themselves. I believe that there's 13 total residents on the road, and as such, 9 of 13 would equal about 70% of the community against this particular recommendation, which to me is significant. It's not a small number, but again, I'll confirm that. The other concern that I have is one of the correspondences I received was from a neighbor who brought to the attention, and I believe the rest of council was CC'd on this, but perhaps I'll get the clerk to confirm. But the neighbor had advised that back in '07, the applicant had contested and or objected to a variance request, citing peaceful refuge currently utilized will be affected by noise and lighting. The variance was not minor. Property can accommodate the setbacks required. Bylaws in place and needs to be adhered to. Visual intrusion and overcrowding of waterfront. Lack of soil and vegetation to absorb the soil and setting a precedent. Which the last comment is where I think I draw the largest concern from my perspective, specifically in the density on 6 Mile Lake and what this would do to create that. And if my understanding is accurate, 13 of these lots on Wild Rice Trail are deemed to be what's, I guess, what they consider to be estate lots, and could likely also be candidates for subdivision as well. And I can only imagine if all 13 residents applied for something similar to this, those 13 would then proliferate to likely 20 to 26 along that shoreline. And so as such, the setting of precedent is quite concerning to me. And then lastly, of course, the impacts to navigation, the impacts to the environment and the shoreline, amongst many other issues. So for all those reasons, I'm concerned about the application, and I am likely not going to be voting in favor for this. And if Madam Clerk, have you concluded with your count?
I believe it is 24 against, 2 in support, and 4 from staff and agencies with comments.
Thank you.
Thank you. And
Through the mayor, I have that information that Councillor Jarvis was requesting. So lot 6 has a frontage of 75.5. However, lots 2, 3, and 5 on that same side of the shoreline have a frontage of 61 or 61.5 meters, with the ones abutting those being 65 and 69.
Thank you for the information. Appreciate that.
all right, I have a few comments, if I may. I appreciate the revised application and that a number of the concerns that were raised beforehand have been addressed, to the lot area and things like that. But that leaves me with 2 challenges. The first challenge is the application is asking for lots with roughly 61 meter frontage, whereas the standard for new lots on 6 Mile Lake under, I'll call it normal circumstances, would be 120. And well, I don't see all the other lots being subdivided simply because most of them are in the 60-odd meter range. I am concerned about the, I'll call it the precedence of saying, even though we have set 120 meters as our new lot creation goal, here we'll allow within that 2 lots instead of 1. But also what is of concern to me is the other item is the 70 meter setback. And Ms. Wanfor, I fully appreciate that you suggested that that was for docks only, not for land-based development. Okay, I'll accept that. But that means that the first lot in the proposal can't have a dock if we were to respect the condition that was put 25 years ago when this subdivision was created. You know, and when I look at this subject, by the way, one of the pieces of paper that I really appreciated, and I'm going to thank, unfortunately, I hate to do this to you, Ms. Bloom, I'm going to thank you, but you gave us figure 10 of the Medland Subdivision Agreement, Schedule D. You probably recognize it. What I liked about this one is it also showed the opposite shore, because the narrow water body has come up in conversation. And I'm not a surveyor, and when I bring out my little ruler, you know it's nowhere near accurate. But I can understand when I look at this why that 70 meters was selected, because it would then, any dock being allowed would be, I'll call it north of the narrowest point of the water body, the channel. And, you know, I think we should respect the fact that when this Medland subdivision was put in place 25 years ago, there were back and forths. I mean, my understanding was the original plan had, I don't know, 5 or 6 more lots on it than the one that we ended up with. And I think the reason that this particular lot that currently belongs to the Reynolds is significantly larger than all the other lots was because it was understood that I'll say half the waterfront, just allow me to round for a moment, half the waterfront is not appropriate for development given the narrowness of the channel in that section, because I don't doubt for a second that if they could have, they would have put 2 or 3 lots there instead of just the 1 back 25 years ago. Now, I wasn't around. I don't know anybody in this room that was necessarily around, maybe 1 or 2 in the back, I'm not sure. But that's my reaction. Now, for all the good reasons that were in the applicant's reports and in our planner's reports, I find myself, I'd be open to subdividing this lot under certain conditions, but not into 3 pieces, but rather 2. Because if it was subdivided into 2 pieces, then the dock serving, I'll call it the new the southerly portion, would be past that 70 meter restriction that was originally created 25 years ago. And I have difficulty, as much as I appreciate all the changes made to the applications and how they addressed most of the issues, I have real difficulty with that 70 meter restriction and saying to everybody, and at that point, I'm sure it was council, I'm sure it was staff, I was sure it was the developer, saying that 70 meter setback for docks was put in for a reason. It was part of the, I suspect, and again, I don't know, so I'm imagining that was one of the conditions that staff and council at the time required in order to approve this subdivision. And I'm afraid I can't vote in favor of this at this point for that reason, that I think we're going back on a condition that we laid down 25 years ago. Maybe it was 24, maybe it's 26. You know what I mean. I mean, this particular schedule is dated February 2000. I think it was some shortly thereafter that the final, I don't think this is the final version because this doesn't show any of that setbacks on, but for me, that's a one hurdle too far. Is saying that 25 years ago, everybody recognized that channel, put that 70-meter restriction in for development. And yes, I understand might just be for docks, but docks is the whole point. Because otherwise, if we create these lots, if we choose to not respect the 120-meter lot width for for creation of new lots, we'd be creating a lot that if we respected that 70 meters would have no water access. And how realistic is that on our part to create a lot on 6 Mile Lake and say to the owners, you can't get on the lake, sorry. You know that's not going to fly. So that's my reason that I cannot vote in favor of this, as much as I respect all the work that's gone into recommending that we approve. I'm sorry, I'm stuck with that 70-meter dock restriction that was agreed to 25 years ago. Ms. Lemieux, you want? I'll let you respond.
Thank you, Your Worship. I appreciate that. And I just wanted to make a note, and I appreciate your comments, that a big part of our review on this application also considered that back 25 years ago when the subdivision was created, back then it's my understanding that the narrow water body provisions in the zoning bylaw for docks did not exist at that time, and those came into play later on. So we felt that the application considered that as a concern, and the existing narrow water body dock provisions that we've made sure this application would adhere to still protects that, even though it's unfortunate that back at that time it was laid out that way. So I just wanted to provide that further context.
And I respect all the efforts being made to minimize the impact. I'm just saying, for me, it's still not enough. And that's just where I'm at. And I see while I went on my little bit that a few more hands were raised. So I'm going to go Councillor Jarvis, Cooper, and Predko, please. Okay. Well, then I'm going to go straight to Councillor Cooper.
Thank you, Councillor Jarvis, for stepping aside. All joking aside, and this isn't joking, but I am very pleased with what I heard the mayor say, because it's right along the lines of where I was with this particular application. And I just will cover off a few things. One of the things that hasn't been mentioned very much, and I noticed in the first application, but I still see it today, and that is with the 2-lot creation versus maybe 1 extra lot, we have roadways that are essentially using up a lot of the land that we're calling acreage and land area and lot coverage, etc. But basically there's a road going down a good portion of this property that, what else could you put there but a road? So then I sort of say to myself, well, maybe the front third of this lot, these lots, it should be considered acreage. The rest of it is a roadway, and it's not really adding to the sort of acreage picture that one would get. So that's something that has not been said. I also happen to be concerned about things like the narrow water body and water quality and etc. I also feel that at the time, and I think even today, that what was intended in this particular narrow water body was larger lots, fewer docks, less traffic, etc. And I think if this had been a skiving off of 1 lot, it might be more comfortable, but 2, it really doesn't make any sense to me. So essentially it could comply in a sense to what the criteria were when these were formed, and it's not. So I say it should comply and must comply. Thank you.
Thank you. Councillor Predko.
Thank you. And through your worship, I don't really have too much different to add at this moment, other than to say that I do think that the 2 severed lots are disproportionate to I think subdivision and the planning guidelines for this area. And if it was 1 lot that was being subdivided at a higher frontage, or even if the property was divided into 3 equally, it might be easier to accept the width. But I do think that the narrowness of the channel and the 70-meter setback is really a problem in that south portion where those two lots are going to be. And, you know, what we've heard from the community is the volume of traffic, both in the summer and the winter. I think that's causing me concern for docks occupying that channel and interfering with the traffic that's going through that channel. Thank you.
Right. Any other comments? Sorry, Councillor Hazelton. You're a little too late on with that trigger, I think.
Tricky guy. Okay, lots have been said. I'm not going to repeat it all. I do want to offer a couple of what I think are a little bit different comments. Just because there are other lots on 6 Mile Lake that are small, I don't think fits into this category or into the criteria for justification. The OP, the zoning bylaws are all designed for new large lots. And I find what has been done, certainly the transition from the first go around to the current go around is a step in the right direction, but I think it's still offensive. I want to provide, by way of reference, an example on in Honey Harbor, just down the shore on the way to the mayor's property. We had a property that was 750 feet. Sorry, I have to talk in feet. I'm not a metric guy yet. 750 feet. We had 400 foot shoreline requirements for a new lot creation. And at the time, the township turned down the request to sever that property into two, leaving that would have left a 400 plus a 350 foot lot, because that 350 foot lot was not 400 feet. And I think that what we have attempted to do in the township is craft OP and zoning bylaws that are very specific as minimums, and this does not in the wildest dreams meet the minimum. And just as an aside, I've heard that the water path is 40 meters, 44 meters, whatever. The characteristics of this property I'm referring to on the north bay of Honey Harbor had a distance of 78 meters across. And so when I look at the experience, the precedent that we set in Honey Harbor with neighborhood plans of 400, don't break it, not 350, it's 400. And on this so-called narrowish water body, I can't see how we could possibly approve this. Thank you.
Thank you. Any other comments? All right. I'm going to read the motion as it is currently written, which is moved by Councillor Cooper, seconded by Councillor Hazelton. Be it resolved that Council receives Planning Services Report 2025-076 and approves bylaw 2025-043, being a zoning bylaw amendment, said 24-17, to rezone 16,000 square meters of lands legally described as Lot 7 on Plan 35M-673, part of Lot 15, Concession 14 in the Township of Georgian Bay, District Municipality Muskoka, and are municipally known as 206 Wild Rice Trail, to a 6 Mile Lake residential exception 66 zone SR6-66, and amend the 6 Mile Lake residential exception 6 zone SR6-6. All those in favor? Okay, just to confirm, all those against? And that is defeated unanimously. Oh, no outbursts allowed in theory. We are now going to do a second motion, which is basically, let's say, be it resolved that Council deny application Z2417 for 206 Wild Rice Trail for the following reasons. And we're going to list a few reasons just so for the record. And I've already started with the narrow water body and the dock restriction of 70 meters from lot line, and lots under the 120 meter shoreline requirement of 6 Mile Lake. Is there anything else? I think they're on side with the acreage, I think. Sorry? Okay. Okay. I'll call it building setbacks under zoning requirement. Councilor Hazelton?
You may want to refer to precedents set previously in our township, holding firm to minimum lot frontage.
Maintain precedents regarding new lot creation. Is that adequate? Okay. So I'm going to have moved by Councillor Pretko, second by Councillor Jarvis. Be it resolved that council deny application Z 2417 for 206 Wild Rice Trail for the following reasons. 1, the narrow water body dock restriction of 70 meters from lot line. 2, lots under 120 meter shoreline requirement of 6 Mile Lake. 3, building setback under zoning requirements. And 4, maintain precedents regarding new lot creation. Councilor Cooper.
I just wanted to commend your initiative here, putting down the reasons. We don't often do that.
You should commend our clerk for remembering. Okay, good. You should commend our director of planning, apparently.
Well, I'm commending you though for including them in as the chair. I'm thanking you for doing that.
Well,
it doesn't always happen.
No, and we've been advised good practice going forward is to do it. So that's why we're doing it.
Excellent.
Councilor Bochek.
Thank you, and through you, Mayor. I don't know if adding this to the list is important or not, but in the report, I didn't see anything about FH1 or FH2 fish habitat, and I certainly didn't see anything about the environmental impact of this. So I don't know if you want to include that in the list, but I think
I'm hesitant to do so because it wasn't part of our discussion and our reasoning today in our decision.
Thank you.
Even though those are very valuable criteria.
Right.
We didn't get that far.
Thank you.
Okay, then I'll say all those in favor. And that is carried. Thank you very much. All right. Sorry. I know we have a committee of the whole scheduled for 1 o'clock with a guest. So therefore we want to make sure we start that. We have a shore road allowance for Haskett's Drive. I don't know if you feel that we can accomplish that in the next 10 or 15 minutes, or if you'd like to leave that for after committee of the whole. Okay, I got 1 vote for lunch. Okay, then we're going to. Okay, then it's be it resolved the council does hereby recess the planning council meeting of May 6, 2025 at 12:17 p.m. and will reconvene following the committee of the whole. And moved by Councillor Hazelton, because he was the one muttering most at me, and Councillor Jarvis muttered less at me. So Councillor Hazelton and Jarvis are the mover and seconder. All those in favor? And we are recessed. Thank you very much. We're going to be back by 1 o'clock for committee of the whole. And that's good because I have to pee.